Asma YouTube'ga kiring, ahvolingni, ovozini. Bir. Keldimi yaxshi? 1 2 3 4 5.
Ras. Ras. Hurmatli mehmonlar, tez orada boshlaymiz. Iltimos, o'rinlaringizni o'tib o'tiringlar. Yok, kliker manda yok. Başlayayım mı? Assalomu alaykum muhtaram forum ishtirokchilari. Kecha 29 may kuni Xalqaro yuridik forumi Tashkent Law Spring doirasida raqamli texnologiyalar davri huquqiy nuqtai nazardan kelajakka qarash mavzusida plenar majlis bo'lib o'tdi. Majlisda turli mamlakatlardan adliya vazirlari va taniqli ekspertlar ma'ruza qilishdi va bu butun forumning yuqori darajada o'tishiga asos soldi. Bugungi kundagi muhokamalarni davom ettirgan holda biz 6-munozara sessiyasi boshlaymiz. Sessiya mavzusi yuristlar texnologiyalar to'lqinida raqamlashuv o'yin qoidalarini qanday o'zgartirmoqda? Yuridik kasbdagi raqamli o'zgarishlar nafaqat ish uslubimizga, balki professional yechimlarga ham ta'sir ko'rsatmoqda. Biz bu yangicha sharoitlarga tayyor bo'lishimiz kerak. Sessiyamiz boshlanishidayoq men barcha ishtirokchilardan telefonlarni ovozlarini o'chirib qo'yishlarini so'rab qolaman. Hurmatli ma'ruzachilardan esa vaqtga rioya qilishlarini va belgilangan reglamentga amal qilishlarini so'rayman. Har bir ma'ruzachiga 13 daqiqa vaqt beriladi va sessiyamizni oxirida savol-javob uchun vaqt ajratiladi. Shuningdek, panel sessiyasi ishtirokchilaridan ochiq va interaktiv muhokamada faol ishtirok etishlarini so'rayman. Menimcha bu eng yaxshi mutaxassislardan nufuzli javoblarni olish uchun noyob imkoniyatdir. Yana bir muhim jihatga diqqatingizni qaratishni istar edim. Forum natijasi amaliyotga oid tavsiyalarni ishlab chiqish bo'lishi kerak. Forumning xalqaro ilmiy amaliy xususiyatini inobatga olgan holda hurmatli ma'ruzachilardan O'zbekiston uchun o'z tajriba va qarashlaridan kelib chiqqan holda tavsiyalar berishlarini so'rayman. Sessiyamiz oxirida biz guruh bo'lib suratga tushamiz. Bugungi munozara sessiyamizni ochish uchun qutlov so'zi O'zbekiston Respublikasi Advokatlar palatasi raisi Sadiqov Shuhrat Shavkatovichga beriladi. Marhamat Shuhrat Shavkatovich, so'z sizga.
Hurmatli xonimlar va janoblar, aziz mehmonlar, hamkasblar, hammalaringizni bugungi sessiyada ishtirok etayotganlaringiz uchun rahmat aytaman hamda qutlayman. O'zbekiston Respublikasi Advokatlar palatasi nomidan va shaxsan o'zim nomidan sizlarni 4-xalqaro yuridik forum Tashkent Law Spring doirasida qutlashdan mamnunman. Bu forum huquqiy jamoatchilik oldida turgan dolzarb masalalarni muhokama qilish, tajriba almashish va kasbiy muloqot uchun muhim maydonga aylangan. Bugungi sessiya mavzusi texnologiyalar to'lqinidagi advokatlar, raqamlashtirish, o'yin qoidalarini qanday o'zgartirmoqda. Ayni paytda juda dolzarb mavzudir. Biz texnologiyalar jadal rivojlanayotgan davrda yashamoqdamiz. Bugungi kunda sun'iy intellekt, avtomatlashtirish, blockchain, elektron sud ish yurituvi va onlayn muloqotlar huquqiy amaliyotning ajralmas qismiga aylanmoqda. An'analar va qadriyatlarga asoslangan advokatlik faoliyati endilikda transformatsiyaga muhtoj. Bu faqatgina chaqiriq emas, balki yangi imkoniyatdir. Biz o'z o'rnimizni qayta ko'rib chiqishimiz, yuridik yordamning ochiqligini ta'minlashimiz, mijozlar va davlat organlari bilan aloqalarni soddalashtirishimiz, advokat faoliyati samaradorligini oshirishimiz mumkin. Raqamlashtirish jarayonlari advokatlar palatasi, sudlar va yuridik kompaniyalar faoliyatiga ham kirib kelmoqda. O'zbekistonda ham bu borada muhim islohotlar amalga oshirilmoqda. Advokatlar uchun elektron xizmatlar joriy qilinmoqda. sohaga kirish tartiblari soddalashtirilmoqda. Elektron hujjat aylanmasi tizimi rivojlanmoqda. Bizning vazifamiz bu jarayonda kuzatuvchi emas, balkim faol ishtirokchi bo'lishdir. Ayni paytdagi sessiyada turli davlatlarning advokatlar uyushmalari rahbarlari, xalqaro tashkilotlar va huquqiy innovatsiyalar sohasida faoliyat yuritayotgan advokatlar ishtirok etayotgani juda quvonarlidir. Ishonchim komilki, bugungi fikr va tajriba almashuv har birimizga kasbiy faoliyatimizni yangi nuqtai nazardan baholash va kelgusi rivoj uchun ilhom olish imkonini beradi. Forum ishtirokchilariga samarali faoliyat, ochiq muhokamalar va yangi kasbiy cho'qilarni zabt etishni tilayman. E'tiboringiz uchun rahmat.
Endi esa biz ma'ruzalarga o'tamiz. Hurmatli ma'ruzachilarimizni sahnaga taklif etaman. David Asatyani, Gruziya advokatlar kollegiyasining raisi. Оп. Отсюда надо было. Здравствуйте. Анар Багиров. Azerbaycan Respublikasi Advokatlar kollegiyasi raisi. Aydin Bikibayev, Qozog'iston Respublikasi Advokatlar kollegiyasi raisi. Mark Hammerson, Curtis Mallet Prevost Hope and Mosul LLP Xalqaro yuridik firmasi hamkori. Erinç Sahkan, Türkiye Advokatlar Assotsiatsiyasi Kengashi prezidenti. Birinchi ma'ruzachimiz Gruziya Advokatlar Assotsiatsiyasi raisi va Yevropa Yuristlar Assotsiatsiyasi prezidenti David Asatyani. Hurmatli hamkasbimiz raqamli advokatura, geografik va huquqiy to'siqlarni yengib o'tish mavzusida ma'ruza qiladilar. Slovo vam.
Dear colleague, this gentleman, it's a great honor for me address today. And digital advocacy coming. We are living through a digital transformation that is fundamental, reshaping the way we practice law. Communication with our clients and often across borders and beyond the constraints of physical presence. The legal profession is undergoing a profound transformation. Digital advocacy is an essential evolution of our profession. Through technology, lawyers now have unprecedented opportunities. They can provide legal consultations remotely, even in the most remote parts. Legal databases can be smart templates and AI-assisted drafting tools, routine tasks, online courtrooms, and e-filing systems remove logistics and geographical barriers, giving clients quicker, more affordable access to justice. International cooperation and transnational litigation become more feasible and effective. However, this transformation is not without its challenges. New tools bring new risks, particularly with regard to data protection and cybersecurity. Ensuring that client information remains confidential and secure must remain a top priority. Digital ethics. As we increasingly rely on AI, automation and digital interface, we must ensure fairness, accuracy, and accountability in our decisions. Professional conduct in virtual space. How do we maintain the same standard responsibility in our online courtrooms or digital communication? As our advocacy modernizes, we must ensure that fundamental values of our profession, independence, confidentiality, and integrity are not compromised in the digital space. In Georgia's justice system, digitalization was made substantial strides. The introduction of the e-justice platform, which includes electronic case management, online document circulation, and remote hearings, has significantly improved efficiency and access to justice. One of the most transformative features in the e-court system, which now allows users to file their cases electronically without having any physical visit court buildings. This development not only saves time and resources, but also reduces regional disparities and accessing legal remedies. It is especially empowering for individuals in remote areas and for those with limited mobility, ensuring that justice is not just a right in principle, but it is also the service available in practice. During the COVID times, these developments were not just useful, they were vital. With access to physical courtroom restricted, digital solutions kept our system functioning and accessible. It was during this period that the shift to remote justice gained momentum. The Georgian Bar Association, in cooperation with the Chief Justice, played an active and instrumental role in supporting and facilitating this transformation. Today, the use of digital technologies in court proceedings is no longer a temporary solution, but a permanent feature of the modern justice system in Georgia. Moreover, at the Bar Association, we recognize our crucial role to guide our profession to these new achievements and environment. We must equip our lawyers with digital tools, training, and ethical guidance needed to navigate a rapidly changing landscape. And I'm proud to say that the Georgian legal profession has taken proactive steps in this regard. Let me share several key initiatives that we, Georgian Bar Association, have taken to integrate digital innovations into our work and to make the practice of the law more efficient, accessible, and modern. First, and the most important, in collaboration with the reputable technological think tank, we have launched a comprehensive, multi-dimensional study aimed at assessing the current digital baseline of the legal profession and identify the key pathways for the future development. This initiative is tackling the major questions head-on: artificial intelligence risks and opportunities, and compliance and ethical challenges, data governance and interoperability, and the practical implementation of the concept like regulation as code and policy as code. We are also exploring what kind of capacity building will be essential for lawyers to operate effectively in this new landscape. It has been an incredibly productive and insightful process so far. And as the project concludes later this year, I'm truly looking forward to share our findings, recommendations, and the strategic roadmap that will emerge from it. Digitalization of qualification exams. Our bar qualification exams are now conducted through a fully electronic examination portal. This platform ensures the transparency and user-friendly process aligned with the highest legal standards. E-learning and accessibility. Our continuing legal education professional development program, we have introduced a digital platform that allows lawyers to manage their training independently. This system was designed with inclusivity in mind. It is fully accessible to persons with disabilities, including with problems of visual impaired users, and also offers hybrid learning options, allowed lawyers from across the country, including those in remote areas, to practice in training without needing to travel to the capital. Digital disciplinary proceedings. All proceedings related to lawyers' ethics are now conducted in a full digital format, from the filing of complaints to hearings and decisions. Every stage is managed online, ensuring flexibility, efficiency, and procedural transparency. Online training and key legal topics. We continue to offer a wide range of online trainings and essential legal areas, including juvenile justice, construction law, intellectual property law, women's rights, children's rights, and the right to a fair trial. These programs empower lawyers to stay informed and up to date. Electronic portal lawyer-client meetings in prisons. In cooperation with the Ministry of Justice and Special Penitentiary Services of Georgia, we have developed a system for scheduling prison visits electronically. This allows timely, confidential, and secure communication between lawyers and their clients in detention, strengthening fundamental legal rights for individuals. Cybersecurity guidelines for lawyers. We have issued practical guidelines on minimum cybersecurity standards, helping lawyers protect clients' data and maintain confidentiality in the digital realm. These guidelines are crucial for maintaining public trust and upholding the integrity of the profession. Lastly, the technology should not be seen as a threat to the legal profession. It is a call to adapt, to grow, and to innovate. Digitalization offers us a chance to better service our clients, to protect rights more effectively, and to make justice more accessible to all. It challenges us to rethink our traditional models, to embrace a future where technology and the rule of law move forward hand in hand. Dear colleagues, we are not just witnesses of changes. We are its architects. It's up to us to shape a future where digital advocacy helps remove long-standing barriers to justice, increase efficiency, and elevates the legal profession to new heights. Let us remember, digitalization is not the end of the tradition. It is the beginning of transformation. Together, we must build a legal profession that is modern, inclusive, ethical, and resilient. Let us advocate more effectively, collaborate more widely, and innovate more boldly for the benefit of our clients, our profession, and our societies. I look forward to our continued journey together. Thank you so much.
Thank you very much. Большое, katta rahmat mazmunli ma'ruza va bildirilgan g'oyalar uchun. Avvalda aytganimdek, savol-javoblar uchun vaqt ajratiladi. Hurmatli ishtirokchilarni savollaringizni tayyorlab qo'yishlaringizni iltimos qilar edim va sessiyamizning oxirida bu savollaringizni ma'ruzalarga, shu jumladan David Asatyaniga berishlaringiz mumkin. Endigi ma'ruzachamiz Anar Ramiz o'g'li Bagirov, Ozarbayjon Advokatlar kollegiyasi raisi, Ozarbayjon prezidenti huzuridagi huquqiy kengash a'zosi, korrupsiyaga qarshi kurashish komissiyasi a'zosi. Anar Ramiz o'g'li Bagirovning ma'ruzasi raqamli asrda advokaturaning kelajagi mavzusida bo'ladi. Marhamat.
Merhamet. Aziz dostlar ve hemkasıplar, hanımlar ve canablar, muhterem Şöhret Şöfketoviç, aziz dostum ve kardeşim, bugün sizler bilen non şehri Taşkent'te jonajon kardeş mehmondost Sergiyoş Özbekistan'ımızda bu iş men üçün katta şereftir. Azerbaycanlılık hamkasıplarınız nomidan şükür hürmet sözlerini yetkasızca iojat bering. Dear ladies and gentlemen, dear colleagues and participants, first and foremost, I would like to extend my warmest greetings to all of you and express my sincere appreciation to the Chamber of Advocates of the Republic of Uzbekistan for the honor of addressing this esteemed gathering today. We are living in an era of rapid technological transformation that profoundly affects every sphere of our lives. Digitalization is not merely a temporary trend. It's an objective necessity that determines the direction of development for both governmental institutions and independent professional communities. The legal profession as an integral part of the legal system and an institution that ensures the protection of human rights and freedoms inevitably encounters the challenges and opportunities brought about the digital transformation. In the context of the rapid evolution of information and communication technologies, we are confronted with the dual task of adapting our professional activities to new conditions while upholding the fundamental principles of legal ethics, independence, and confidentiality. The digital age demands from lawyers not only a high level of legal expertise, but also competence in the use of modern digital tools. This is particularly relevant in the context of enhancing access to legal assistance, optimizing internal procedures, and ensuring effective interaction with public authorities and civil society. In this regard, I find it essential to highlight that the Azerbaijani Bar Association is undertaking consistent and targeted efforts toward the digitalization of its operations. These measures aim to strengthen the institutional capacity of the legal profession, increase transparency and efficiency, and ensure professional resilience. As of today, ABA has implemented essential digital infrastructure that automates its core processes. All procedures and services are now accessed through the association's official website, which serves as the main online platform for interacting with both lawyers and applicants. The website features a public electronic registry of all licensed lawyers, where citizens can access essential information, including years of experience, specializations, contact details, and other relevant data. Notably, the application process for joining the bar is conducted entirely in electronic form. Candidates submit all required materials through personal electronic accounts, and upon receiving the status of a lawyer, this account transforms into a full-fledged personal cabinet, providing continuous access to a range of professional functions. Through these personal accounts, two-way correspondence is mentioned between lawyers and the governing bodies of the Bar Association. Official documents, including decisions, notices, and other materials, are transmitted via the system, thereby facilitating prompt and transparent business communication. Using the same electronic interface, active lawyers gain access to functionalities that allow to participate in online training and educational events. The electronic accounts serve not only as a means of communication between attorneys and the Bar Association, but also integrated with the electronic court system, enabling real-time tracking of court case statuses, receipt of updates on case progress, and timely response of changes. It should also be noted that decisions regarding the provision of state-funded legal aid are formed and transmitted electronically. The Legal Aid Center forwards such decisions to the appropriate bureaus and organizations based on the number of available lawyers and in accordance with the principles of fair case distribution. Furthermore, both lawyers and citizens have the opportunity to submit their requests and inquiries electronically through dedicated sections of their personal accounts and the Bar Association's website. This greatly simplifies the interaction process and significantly reduces administrative burdens. A major step towards digitalization was the introduction of the first stage of the qualification examination in electronic format. Candidates receive their test results on site, which significantly enhances the transparency and objectivity of the procedure. The work of the Academy of the ABA also deserves special mention. The Academy regularly organizes continuing education programs in various formats, whether in person, offline, hybrid, or entirely remote, online. This ensures equal access to education for lawyers working across different regions of the country, contributing to the strengthening of professional standards, the expansion of competencies, and the continuous exchange of knowledge within the legal community. Particular attention within the activities of the Bar Association is devoted to cybersecurity. All employees of ABA bodies undergo regular training and pass relevant certification exams, enabling the timely identification and prevention of potential cyber threats. This ensures the reliable protection of confidential information and supports the secure operation of the bar's entire digital infrastructure. One of the most significant achievements has been the introduction since 2023 of an electronic warrant system that allows lawyers and their clients to sign contracts in digital format, regardless of their geographical location. This innovation significantly reduces both time and financial cost for lawyers and clients, enhancing the efficiency and flexibility of legal service delivery. I think it will be interesting for our post-Soviet countries and East European countries because we have the same systems of orders, warrant, it's the mechanism, special document which issued by the Bar Association and for execution by the attorney, his obligation to represent the interests of the client in the court. And I think that most of our countries, including Uzbekistan, also use this order warrant system. That's why I think that it is interesting for you, our Uzbekistan colleagues, and other our friend countries. And I think that we are ready to exchange our experience. in these issues, in this field. In 2024, with the aim of further simplifying and digitalizing legal practice, the Bar Association developed and launched the e-Vakil electronic application, which integrates all the main functions of the personal user account. Through this application, lawyers can sign electronic contracts, track their cases, participate in educational programs, and carry out other professional activities in a user-friendly digital environment. Another effective tool for enhancing public access to legal assistance is the Legal Aid mobile application. It is available for download on the App Store and Google Play. The application enables users to obtain qualified legal advice via their mobile devices. Upon installation, users can register, submit their legal inquiries, and receive a response from a qualified lawyer 24 hours a day. To ensure a comprehensive approach to digital and transformation, the ABA has established dedicated committees on electronic advocacy and cybersecurity. These committees consist of lawyers with advanced expertise in both information technology and law. They conduct expert analysis of existing legislation, develop proposals for its improvement in the context of digital transformation, and organize training sessions and educational events for their colleagues. Their activities play a vital role in shaping strategic approaches to the digitalization of the legal profession and ensuring its sustainability amid modern challenges. In the near future, as part of the initiative of the Committee of Electronic Advocacy, the launch of a new digital tool, the Pro Bono chatbot, is planned. Based on artificial intelligence technology, this chatbot will provide citizens with free legal assistance in an automated format by responding to common legal questions and directing users to relevant resources. The project aims to expand access to justice, particularly for socially vulnerable groups, and will serve as an important complement for the existing mechanisms of pro bono legal support. Despite the progress made, we must continue active efforts. Digitalization is an ongoing process that demands continual knowledge renewal, the implementation of innovative solutions, and the ability to adapt to rapidly changing conditions. The future of the legal profession in the digital age is directly linked to its ability to uphold its core professional principles, independence, ethics, and confidentiality, while making full use of the advantages offered by modern technologies. This involves not only technological advancement, but also the fostering of a digital culture within the legal community, strengthening international cooperation, developing digital legal infrastructure, and ensuring ongoing education will be the cornerstones of the sustainable development of the legal profession in the 21st century. The Azerbaijan Bar Association recognizes these challenges and is committed to keeping pace with contemporary developments by upholding its long-standing tradition while actively embracing innovation. And I think that today, Tashkent Spring Law Forum is one of the main legal platforms of legal thought in our region, and I am very happy to be with you and to discuss all these problems. Thank you very much for attention.
O'zbekiston Respublikasidagi advokatlar uchun mo'ljallangan raqamli dasturlar haqiqatdan ham juda o'xshar ekan Ozarbayjon Respublikasidagi dasturlarga. Lekin sizlarni dasturlaringiz farqli qiladigan joyi kengroq. Ya'ni sizlardan o'rganadigan ko'p elementlar bizlarga mavjud. Katta rahmat ma'ruzangiz uchun. keyingi ma'ruzachimiz Qozog'iston Milliy advokatlar kollegiyasi raisi Aydin Bikibayev. Aydin Bikibayev o'z ma'ruzasini hozirgi sharoitda advokaturani tashkil etish modeli mavzusida olib boradi. Вам слово.
Рахмет. Құрметті өзбек бауырлар, құрметті әріптестер, әр мемлекеттен келген. Біріншіден алғысымды айтам, осы шараға шақырып, сөз беріп жатқандарыңа, менің әріптесім Шухрат Шапқатовичқа шақырып, бәрін төлеп, қайта звондап, келіңіз деп айтқан соң енді келіп отырмыз. Үлкен рахмет, алғысымды айтам. Енді рұқсат етсеңіздер, мен кішкене бәріне түсінікті болсын орысша сөйлейін. Казахстан также находится в процессе цифровой трансформации. Электронное правительство, банковские суперапы, маркетплейсы, онлайн-сервисы – это норма сегодняшней жизни для всех наших граждан, для граждан нашей страны. В этой среде адвокатура не может оставаться в стороне, мои коллеги это подчеркнули. И это, конечно же, мы живем в новой профессиональной реальности. Вопрос здесь не стоит там быть или не быть в цифре, а в том, как сохранить правозащитный характер адвокатской профессии в новых технологических условиях. Вы все знаете, что адвокатская профессия, она связана с специфическими привилегиями, ограничениями своей деятельности, а также иммунитетами. В том числе вы иммунитеты знаете, у нас в Казахстане в отношении адвоката нельзя проводить негласные следственные действия, за исключением подозрения совершения особо тяжких преступлений. Другие иммунитеты есть, которые позволяют нашей профессии быть защищенной. Мы стараемся эти иммунитеты развивать. Вот совсем недавно Мажилис парламента принял закон. Теперь клевета в отношении адвоката, угроза его жизни, насильственные действия наказываются так же сурово, как клевета, те же действия в отношении судей. То есть статус адвоката приравняли к уровню носителей публично-правовых функций. Также ввели формальный состав преступления в виде воспрепятствования адвокатской деятельности, формальный состав, то есть не надо доказывать последствия. И виновные лица, я думаю, будут жестко привлекаться к ответственности, и это позволит поднять статус адвокатской профессии в Казахстане. Вместе с тем, помимо этих иммунитетов, вы знаете, у нас есть и ограничения. Это в том числе адвокатская тайна. И использование вот этих цифровых сервисов, конечно же, вызывает вопросы, насколько, где граница, будет ли нарушена адвокатская тайна. Понятно, что большинство этих сервисов государственные, да, и тем не менее там есть ГЧП, государственно-частное партнерство, поэтому вопросы имеются, и мы в адвокатуре Казахстана думаем, как эту проблему решить. То есть мы также находимся, как наши коллеги, в процессе осознания, в процессе принятия решения по этому вопросу. Значит, у нас электронное лицензирование, e-license, все лицензирование деятельности адвоката осуществляется исключительно в электронном формате. Конечно, это прозрачность процедуры, исключение коррупционных рисков, доступность. У нас в Казахстане адвокаты пользуются информационной системой «Единый реестр досудебных расследований». То есть все дела, уголовное дело, адвокат может ознакомливаться электронно. Ему дается доступ с момента регистрации досудебного расследования. И он может там ознакомливаться непосредственно с материалами дела. Ему не надо ехать сейчас непосредственно следователю, прокурору. Вместе с тем, конечно же, есть проблемы использования этой системы. Мы раз в полгода встречаемся с комитетом по статистической, КПСУ у нас называется, по правовой статистике. Он уполномоченный орган в части ведения этой информационной системы. И вот каждые полгода мы делаем то, что, как функционирует, какие проблемы, и вырабатываем техническое задание на новый период. И мы последний раз тоже вот недавно встречались, выработали свои предложения, чтобы еще улучшить эту систему. То есть По уголовным делам вот эти определенные у нас преимущества сейчас появились. Гарантированная государством юридическая помощь. Она проводится в рамках информационной системы ЗАН-КМГ. Эта система автоматизирует назначение адвокатов по гарантированной государственной юридической помощи. То есть следователь при назначении адвоката высылает информацию, и эту информацию видит неопределенное число адвокатов, и любой из них может принять. Вот этот коррупционный составляющий мы хотим снять. Понятно, мы в коллегиях территориальных организовываем дежурство, чтобы эффективно закрывать, потому что в ночное время могут быть задержания, да, чтобы оперативно адвокат такой был доступен. И эта система на сегодня в том числе дает доступ адвокатов к различного рода информации, а также через нее можно в рамках гарантированной государством юридической квалифицированной юрпомощи делать онлайн-консультации. Эта система государственная. Государство хотело передать его нам на баланс. Прошло 7 лет, мы отказываемся, потому что система нас не удовлетворяет. Хотя с точки зрения адвокатской тайны, наверное, нам в итоге эту систему надо забирать, чтобы сама коллегия адвокатов контролировала вот эти данные, чтобы адвокатскую тайну гарантировать. Вопросы есть, но пока мы в процессе. Значит, у нас есть дальше судебный кабинет, но она такая же, как мои коллеги в Узбекистане показывали, в Грузии мне показывали. Такая же система, подача исков, жалоб, ходатайств в онлайн-формате, уведомления, дистанционное ознакомление со всеми судебными решениями. Есть, конечно же, проблемы. Часто там ввиду различных проблем бывает, что эта система не работает. Там начинают коллеги писать в соцсетях, почему, когда. Наверное, это общая проблема. Тем не менее, работа в этой системе совершенствуется. Они нам обещали обновление этой системы выкатить и обещали интегрировать систему ТУРЮЛИК с системой гарантированной государственной юридической помощи ЗАН-КМГ, что еще больше улучшит. Значит, мы в адвокатуре вот эти статистические отчетности начали переводить в цифру, то есть некоторые наши территориальные коллеги запустили сейчас пилотный проект, вся отчетность внутри нашей системы, чтобы она была в электронном формате. На уровне республики мы это дело сейчас этим занимаемся. Конечно, есть другие информационные системы, но они наверняка есть в каждой стране, эти информационно-справочно-правовые системы. Да? Есть система обмена документами с госорганами, там у нас частная компания, у нас есть претензии к этой компании, мы с этой компанией разбираемся, потому что мы считаем, что там есть некоторые ограничения конкуренции, доступа на этот рынок, и, соответственно, мы видим некоторые эксцесс использования значительной рыночной власти, которые есть у таких компаний, которые в узловые вот эти системы вошли и могут злоупотреблять потенциально своим доминирующим положением. Что мы себе приоритет ставим? Да? Конечно, это унификация этих цифровых сервисов, электронного правительства, ЕРДР. ЕРДР – это где досудебное расследование мы материалы берем, ЗАН-КМГ и лайсенс судебных сервисов в единую цифровую экосистему. Ключевая задача, и мы в тесной связи со всеми государственными органами. Все делается с учетом наших пожеланий техническому заданию, которое они каждый год вначале разрабатывают, и в середине года мы с ними подводим промежуточные итоги, в конце окончательно. И это позволяет нам совершенствовать эти системы. Цифровизация, конечно же, идет стремительно. Чат GPT, наверное, уже главный инструмент юристов. И на базе чат GPT и китайских сервисов у нас появляются новые электронные сервисы. Наверное, у вас тоже адвокаты пользуются. По-моему, скоро люди перестанут сами готовить документы. Все видно уже, откуда этот документ появился по его стилю написания. Казахстанская адвокатура не пассивный наблюдатель, и мы полноценный участник этого процесса. Мы формируем запрос на цифровые решения, ориентированные на эффективную работу адвоката. И мы стремимся к модели, когда технология должна работать исключительно на справедливость, обеспечивать адвокатскую тайну. Мы верим, наша профессия не исчезнет из-за этих сервисов искусственного интеллекта. Мы верим в нашу институциональную силу. Я уверен, что адвокатура Казахстана будет такой же, объединяя всех профессиональных судебных представителей, как это есть у вас в Узбекистане, как это есть у моих коллег в Грузии, как это есть у моих коллег в Азербайджане и как это есть у моих коллег в Турецкой Республике. Пока у нас есть вопросы в этом направлении, но мы идем к этому, и мы верим, что адвокатура Казахстана, она будет такая, какая она есть в Европейском Союзе, какая есть у моих здесь сидящих коллег. Спасибо большое.
Содержательный доклад. Нам было очень интересно послушать ваш опыт. Так же, как опыт Грузии, Азербайджана, он очень родственный для нас. Не боитесь ли вы, что и судебная деятельность, и взаимосвязь адвокатов с палатой, с коллегией адвокатов полностью утратится и перейдет в онлайн-формат? Не могли бы прокомментировать этот вопрос, ответить на него?
Также и взаимоотношения между адвокатами, оно всегда будет требовать физического присутствия и с подзащитными, и с коллегами. Вот живое общение, как я вот сегодня обнял своих коллег, Анар Багирова, да, Давида, ничто это не заменит. Поэтому я не верю, что будет это оставаться всегда. Спасибо.
Кейинги мa'ruzachimiz Mark Hammerson, Curtis Mallet Prevost, Colt and Mosel LLP, London, Xalqaro yuridik firmasining hamkori. Janob Hammerson yuridik amaliyotda sun'iy intellektdan foydalanish mavzusida o'z ma'ruzasini aytadi.
Thank you.
Marhamat.
Distinguished guests, ladies and gentlemen, it's an honor to be invited to discuss the wave of technology in the legal profession. My focus is on artificial intelligence. Of the topics discussed on this panel, I believe that AI is the most transformative and disruptive issue we face. How will highly trained, well-paid, busy, error-prone professionals compete with machines performing the same task quicker, cheaper, with fewer mistakes, and working 24 hours a day? Will AI be an additional tool to help lawyers, or will it, as some fear, replace us? My talk is in 5 parts. To begin with, does law need AI? I then describe how AI is currently used. In the 3rd and 4th sections, I discuss positives and negatives. Finally, I make 10 predictions. This is
Раз.
1, 2, 3, 4, 5.
Ras, ras. Yo'q, kim aytdi? Хотя бы anglisham bilan nima man sessiyamni o'tkazdim. Endi hammasi o'tish kerak. Hurmatli hamkasblar, texnik muammo bartaraf etildi va biz davom ettirishimiz mumkin. Hammangizni zalga taklif qilamiz. Assalomu alaykum. Anglishani ma'ruzasi juda chiroyli. Anglishani ma'ruzasi juda qiziqarli. Hozir davom qilamiz. Muammo bartaraf bo'ldi. Hurmatli hamkasblar, texnik muammo bartaraf etildi va biz davom ettirishimiz mumkin. Hurmatli hamkasblar. Hurmatli hamkasblar. Ras. Hurmatli hamkasblar. Ishlamayapti-ku. Ishlamayaptimi? Mikrofon. Hurmatli hamkasblar, ras. Ras. Hurmatli hamkasblar, texnik muammo bartaraf etildi va biz davom ettirishimiz mumkin. Sessiya ishtirokchilaridan yuzaga kelgan texnik muammolar uchun uzr so'raymiz, ayniqsa hurmatli ma'ruzachimizdan. Endi esa sessiyamizni davom ettiramiz va juda qiziqarli ma'ruzani diqqat bilan tinglaymiz.
Ladies and gentlemen. Some people say that lawyers and technology don't go well together. I don't know why. If you would indulge me, I'll start from the beginning. distinguished guests, ladies and gentlemen, it is an honour to be invited to discuss the wave of technology in the legal profession. My focus is on artificial intelligence. Of the topics discussed on this panel, I believe that AI is the most transformative and disruptive issue we face. How will highly trained, well-paid, busy, error-prone professionals compete with machines performing the same task quicker, cheaper, with fewer mistakes, and working 24 hours a day? Will AI be an additional tool to help lawyers, or will it, as some fear, replace us? My talk is in 5 parts. To begin with, does law need AI? I then describe how AI is currently used. In the 3rd and 4th sections, I discuss positives and negatives. Finally, I make 10 predictions. This is a dangerous exercise, and if I was giving a speech about the internet 30 years ago, I would not have anticipated the multiple applications of the web in every aspect of our lives today. Time will be my judge about my predictions for AI. Let's start with an easy question. Do lawyers and clients need AI? I answer this with a definitive yes. Legal costs are prohibitively expensive for all but large businesses and wealthy individuals. High costs, together with law's complexity, result in legal advice not being widely available. Both issues, costs and complexity, combine to mean that clients lack access to justice. People do not have the money for lawyers. Furthermore, governments with limited budgets will not subsidise legal services for any matters other than criminal justice. In most areas of law, the state is indifferent as to whether or not a person is advised. AI will increase access to legal services. We can all agree that this is a good outcome. Next, let's discuss competition. Law operates in a competitive environment. Professional services firms are consolidating. Accountancy firms now undertake legal work. Non-qualified consultants advise on issues which were once the monopoly of lawyers. Professions exist, such as the financial and tax advisors, which overlap with legal advice. Each of these non-lawyers is trying to grow revenue and offer legal services. Law is an old profession, but this does not give us an unchallenged failure to adopt technology will make lawyers irrelevant and subject us to competition from or merge it into other professions. Within the legal industry, competition is fierce. Law firms compete. Law firms Within the legal industry, competition is fierce. Law firms compete against each other for work. firms not using AI will not survive. Charles Darwin, the biologist who devised a theory of evolution, is incorrectly thought to have believed in the survival of the strongest. Darwin, in fact, held that it is not the strongest of the species that survives, nor the most intelligent. It is the one that is most adaptable to change. Law as an industry, law firms and legal departments as organizations, and lawyers as individuals must accept change. Finally, humans make mistakes. Common causes of malpractice are solvable by AI. The legal industry in the US pays $4 billion a year in insurance against malpractice. This figure indicates potential savings for lawyers if mistakes are reduced and the decrease in harm to clients that can be avoided. By AI, I mean a machine that copies human cognitive functions such as reasoning and learning. We are all at the start of the AI revolution. Despite its early stage, AI already operates at the level of a junior lawyer. But just as a junior lawyer's work is checked by a senior lawyer, AI's output still needs to be verified by a human. In the same way as a junior lawyer grows into a more competent senior lawyer, so AI, with its ability to learn, will improve. For transactional work, it already drafts documents, analyzes contracts, and conducts research. In disputes, it performs discovery. AI is good at this type of task, requiring pattern recognition. Lawyers have used e-discovery for many years. A more recent development is AI's ability to predict the likely success of pursuing a claim. If clients have an accurate method of predicting an outcome, will they be so keen to pursue weak cases? Will this lead to a reduction in litigious behavior? Research, a common task previously performed by juniors, is now quicker using AI, analyzes more data, and produces better memoranda than humans. Legal research is an obvious area where AI will perform about 75% of the task. Before focusing on the negatives, let's discuss the benefits. AI works more quickly than humans. Since lawyers are under ethical obligations to keep their fees reasonable, we are required to use the most efficient tools available. That is the regulatory reason to adopt AI. But a much more immediate issue is that in a competitive market, a firm will not survive if its fees exceed market rates. In some tasks, AI makes less mistakes than humans. Lawyers also have legal and ethical obligations to provide the most competent advice. If a lawyer is not using up-to-date technology, then he fails in these obligations. But more importantly, his competitors gain an advantage in their use of AI. Insurers may be unwilling to offer cover for a firm not using AI. In summary, Lawyers need to adopt AI in order to survive. What then are the downsides? AI hallucinates. Its advice can be incorrect, or even if correct, it cites the wrong source. In a dispute, when notifying your opponent of your legal source is important, a so-called misgrounded answer, i.e. an answer that is correct but cites an incorrect source, is problematic. Hallucination is a well-publicized problem. It is an issue which I believe will improve over time. For these reasons, I will not spend further time discussing the issue today. That is not to say it is not a real problem. I just believe that it is a problem which is already understood and which in time will be solved. I want instead to talk about a less discussed issue. Firms charge based on time spent by a human performing a task. We do not charge the costs of hardware and software. How should we charge when software is expensive, but the performance is by a computer, not a human, and the time taken to perform the task is much less? Today, lawyers are incapable of conceiving a fee model of how to charge in these circumstances. This needs to change. A survey in 2023 by Goldman Sachs predicts that 44% of legal tasks will become automated. The impact of AI cannot be denied. So let's assume that in the future, 44% of legal tasks will be performed by a machine. Here are my 10 predictions. Firstly, AI will self-learn and improve. Mistakes will reduce. The comparison of AI to being a junior lawyer will get better. 2, lawyers who do not adopt AI will not survive. Thirdly, law firms that do not adopt AI will not be eligible for insurance. 4, AI requires law firms to rethink today's model of charging by time spent. Instead, we need to move to a new system of charging. Law firms will invent new fee structures reflecting the cost of capital-intensive software rather than time spent by humans. 5, AI will become a major expense for lawyers. 6, the expense of AI means that law firms need scale to afford the technology. The industry will consolidate to something similar to the accountancy Big Four. I do not suggest that the legal industry will be left with only 4 large law firms. Because of conflicts of interest, the number needs to be larger. However, I believe that the cost of AI will require industry consolidation. 7, access to justice and e-courts will increase the number of low-value disputes. 8, predictable dispute outcomes will reduce the number of high-value disputes. 9, lawyers will find it harder to differentiate themselves when they are all using the same software to produce the same answer. Lawyers must improve on the work not performed by machines. This is the high-end, strategic, emotional, highly specialist work that a competent, experienced, business-minded, solution-minded lawyer can provide. Lawyers will become better at performing a smaller subset of work. Lawyers need to serve as both legal counsel and strategic business advisor. Finally, since young lawyers do not leave law school with real-life experience, high competence, and with a business education, law schools will train students to start work with higher levels of competence. Legal training will incorporate higher amounts of subjects taught at business schools so that juniors start work with a better ability to perform at a high level. The combined role of business advisor and professional service provider is one in which accountants excel. Business advice is an area in which lawyers have been perceived as being too academic. In order to compete in the modern world, lawyers need to change this. So let's use AI to create time for lawyers to perform the high-value strategic advice that they enjoy. Let's use AI to perform the menial jobs that lawyers don't enjoy. Let's use AI to widen access to justice. We may do less, but what we do, we will do better, and it will be more enjoyable. And lawyers, as an evolutionary species, will survive. Thank you for your time.
Bu juda qiziqarli ma'ruza bo'ldi va biz hattoki kasbimizning kelajakka oid juda qiziqarli o'nta prognoz eshitdik. Xalq maqolida aytilganidek, vaqt o'z so'zini aytadi. Endi esa so'z navbati keyingi ma'ruzachimizga Turkiya Advokatlar Palatalari Ittifoqi prezidenti Erinç Saggan janoblariga beriladi. Uning mavzusi huquqshunoslik kasbi va raqamli asr, tahdidmi yoki imkoniyat? Marhamat.
Thank you. Selamun aleyküm kıymetli forum iştirakçileri, hanımlar ve cenaplar, sizleri Türk avukatlar adına saygıyla, sevgiyle, muhabbetle selamlıyorum. Dear participants, dear colleagues, first of all, since the presentation is in English, I have to read from my notes, so I ask for your understanding. On behalf of the Union of Turkish Bar Associations, I greet you all respectfully. I am very pleased to take part in the 4th Tashkent Law Spring International Forum hosted by the Ministry of Justice of Uzbekistan. It is very meaningful that this forum, now in this 4th year, is being held under the theme, The Age of Digital Technologies, a Legal Perspective on the Future. This shows that we are addressing the relationship between law and developing technology in a serious manner. In my presentation today, I will talk about the impact of digital transformation on the legal profession in terms of two aspects: threats and opportunities. Digital transformation is not just a technological change. It also requires us to reconsider the legal profession in terms of its structure, ethics, and society. This era refers not only to technological changes, but also a professional, social, and ethical transformation. Main changes brought by the digital era. Digitalization is not only changing the functioning of professions, but also how people access justice. Today, many technological tools are being used, from database decision-making tools and analyzers supported by AI, to blockchain-based land registry systems and remote court hearings. Legal services are no longer limited to physical courtrooms. They now also take place on online platforms, in data centers, through digital interfaces, and even in systems where algorithms play a role. The effects of this transformation are different in each country, but there is a common trend. In European Union countries, electronic case management systems and e-justice platforms have been widely used to make the judiciary more efficient. In China, there are pilot programs with AI-supported decision systems used in simple legal disputes, raising questions about the limits of such technologies. In Anglo-American legal systems, especially large law firms use algorithms to sort contracts and arbitration files. A similar digitalization process is happening in Turkey. The National Judiciary Informatics Systems has been an important step in moving judicial processes into a digital environment. Developments like online hearings, the use of video conferencing for courts, and remote works of lawyers are practical examples of this change. Bar associations are not just observing the process, but are also actively involved, increasing their efforts in training and policy development. Threats of the digital era: professional limits and ethical problems. Digitalization has a lot of advantages, but it can also create new problems for job security and professional identity. Like all new technologies, it can cause unfairness, power issues, and ethical concerns. Automation of legal profession and the risk of loss of employment. First of all, when AI systems take over some basic legal tasks, there is a risk that job opportunities for lawyers might decrease. Tasks like legal advice, drafting documents, and providing advice based on court decision can now be done by software. This is a serious threat, especially for young lawyers and also for senior lawyers who struggle to adapt to these new technologies. This raises not only economic concerns, but also questions about fairness and professional equality. Ethical violations and professional secrets. Another important risk is that professional secrets might not be protected in digital environments. The confidentiality between lawyer and client could be harmed due to security gaps in digital systems. Cloud-based storage, in particular, is open to outside threats. Therefore, it is necessary to create new rules to protect personal data and stay within ethical boundaries. Inequality in access. Some say that thanks to digitalization, access to justice is easier, but this may not be true for everyone. Online court processes may be difficult to follow up for citizens who have limited access to technology, thus preventing access to justice. This creates a new kind of unfairness. During the pandemic, we also saw that people without access to digital tools were left behind. Opportunities of the digital era: enhance law, enhance legal profession. If managed well, digitalization can make the legal profession stronger, more effective, and easier to access. Lawyers who use technology as a skill met today's demands and make their more sustainable and strategic. Our coming limits of space and time, using big data for evidence analysis, and offering international advice online are some examples on how to expand the activities of lawyers. Technology is not something that makes lawyers less useful. If used correctly, it makes the lawyer a more strategic actor. In the models where AI is used as a supporting tool rather than a decision maker, the lawyer's judgments and ethical understanding become more important. This shows that it is possible and necessary to integrate technologies in the essence of the profession. Speed and efficiency. Electronic case systems, online document management, and recorded trials offer important advantages in terms of time and cost. Such systems help with the administrative burden of lawyers, and they have more time for their clients. Evidence analysis and AI. Thanks to AI-supported evidence analysis systems, risk and case analysis can be made before the decision using big data. These tools enhance the lawyer's strategic positions, especially in business disputes. Internationalizations and access. Also, the fact that legal services are now crossing borders helps lawyers become more visible internationally. Remote consulting, online arbitration, and mediation are changing the profession on global level. What should we do? A common roadmap for the legal profession, ethics, training, and regulation. In the digital age, the transformation of the legal profession is not just about keeping up with technology, but also about building the ethical, educational, and legal foundation to manage change, including topics like digital literacy, data ethics, and AI law in law schools could be an important first step in this process. Professional organizations should also offer trainings in digital spaces, set the ethical standards for electronic legal applications and digital advocacy. The lawyer must not only represent the ethical values of persons, but also of the system itself. Digital literacy training. Other than traditional classes, the law school must also offer courses on digital literacy, AI law, and data protection law. Bar associations must develop technological models to allow lawyers to be informed about new software and digital tools. Updating ethical codes. Ethical principles must be reconsidered and regulations must be made to protect professional secrets in the digital environment. Responding to the new conditions of the digital age is only possible with international cooperation. Lawyers should guide technology instead of developing it. Lawyers must become actors that not only adapt to the technology but guide it. This is possible with a professional understanding that works together with technology developers at the public regulations and take action about digital rights. Finally, the future is not giving up in the face of threats, but turning those into opportunities. The digital era is not a threat to weaken the legal profession, but an opportunity to enhance its social aspects. When managed well, this era will make lawyers more accessible, informed, and universal. Here, we must decide. Will we become passive observers or active subjects of this transformation? Leading technology is only possible by protecting the ethical and social values. As the Union of Turkish Bar Associations, we consider this issue more than just a technological one. We consider it as an opportunity to build again the social power of law, access to justice and professional dignity. It is our joint responsibility to lead this process for a more fair future for not just lawyers, but for all members of the society. Thank you all.
Katta rahmat, hurmatli janob Erinch Sahkan. Sessiyamizni davom ettirish uchun barcha ma'ruzachilarga minnatdorchilik bildiraman va sahnaga ham moderatorimiz Nalim xonimni Osiyo taraqqiyot banki katta yurist konsultlaridan birini taklif etaman hamda keyingi ma'ruzachilar bilan moderatsiyani davom ettirish imkoniyatini unga topshiraman. Mrs. Nalim, I invite you to the stage and hand over the moderation to you. Спасибо вам всем. Да, я имею в виду, вы все спускаемся, да?
First, I'd like to thank the speakers from the first panel. Please give them another round of applause.
Okay, great. Thank you so much. Can I also ask for the room to help clean up the water, and while for our new panelists to come up, and I'd also like to thank Mr. Davronbek. Thank you so much for moderating the first panel.
Okay.
Okay, I'm very excited to be moderating this second section of the panel, and I'd like to ask the speakers to please come up and take your seats.
Hurmatli ishtirokchilar, biz keyingi ma'ruzachilarni taklif qilamiz sahnaga. Flora Huang, Yevropa Ittifoqi arbitri, savdo va barqaror rivojlanish bo'yicha ekspertlik guruhlari raisi, Yevropa komissiyasi.
Okay, Ms. Flora Huang, would you like to please come up?
Fayzulla Husan Hajayev, Dentes Xalqaro advokatlik firmasi sherigi.
Mr. Han Yong'an 先生，请上来。
Han Yong'an, Butun Xitoy advokatlar assotsiatsiyasi vitse-prezidenti. Abdullah Sodiq, Gulamov Sadiqov and Partners advokatlik firmasi boshqaruvchi hamkori.
Okay. Thank you, Mr. Davronbek. Okay. Thank you. Well, we heard a very interesting, engaging discussion in the first panel session from the bar leaders, and I think it was very important to hear from the leaders of the legal industry what their vision is and where they see our technological trends taking us. We're going to continue this discussion with this panel. We will have a member of, a leader of a bar association. Mr. Han is the leader of the Chinese Bar Association. But we also have a more diverse panel with an expert speaking on a particular topic on ESG, Ms. Flora Huang, that will bring a little bit more of a diverse perspective to the practice of lawyers in this new digital age. And then, of course, we have two other practicing lawyers with us today to share their experience of technology. So without further delaying the session, we're going to have Miss Flora. Would you like to take the stage, please? Flora, do you have the clicker device? Technology team, can we have the clicking to change the slides?
You can take it.
Thank you.
Good afternoon, everyone. My topic is a little bit different from others. I focus on the ESG. ESG, environmental, social, and governance, is a set of the criteria to help the investor to assess company the sustainability, the performance. It very close rely on this UN the SDG, as part of the 2030. This agenda of sustainable development. So in this case, ESG provide very practical framework for the investor and the business to decide what kind of economic activity that belong to the sustainability. Talk about ESG, but indeed the people have a very different view on the ESG. Some people think that ESG is very important for our future, but other people, they don't believe it. They think it's only a trend or even a scam. A lot of people still very concerned how useful ESG it is, but whatever it is, the ESG is become very important for our daily life, for our whatever in the investment decision and the legal ones. Today, I will go through the 4 parts. I will give you some kind of idea, the legal framework from the global and the different regions, how they define the ESG, and then what are the core this divergence between them. And also, I will give some idea on the challenge and the opportunity for the lawyers. ESG is growing very rapidly, and largely from the voluntary requirement to the mandatory. From here, you could see that EU is taking the lead in the ESG regulation with very comprehensive framework. It already published a lot of the ESG regulations. At the heart of this is for example, I give example sustainable finance disclosure regulation require that all the company you have to disclose how you incorporate ESG in your investment decision. And then the EU also have is the taxonomy. This taxonomy is a classification system to define what kind of economic activity that are considered environmental. Then they have 2 new directives. One is the Corporate Sustainability Reporting Directive. That one broaden the scope of the reporting for a wide range of company. Whatever you are EU company or non-EU company, so you have to be reporting the obligations. The second one is the Corporate Sustainability Diligence Directive. That one imposes mandatory human rights and environmental consideration on your all these operations. US, when we look at the US, is also the catching up is lead. With the SEC proposed this climate disclosure rules, and that one, the rules try to impose requirement on the listed company. You have to disclose environmental risk and the greenhouse gas emissions. And some states, for example, like the California and the New York, that you can also see they have their own ESG regulation. For the UK, when you look at the UK, before the Brexit, it pretty much consistent with the EU. But now that the UK try to develop is the ESG architectures. For example, there's the transition plan, the task force. That one that they require this the set or the standard for the company. You have to publish your plan, how your transition to the net zero economy. Also, this the sustainability disclosure requirement. They require the company you have to disclose all this climate change related reporting. Now the UK also developed its own green taxonomy. That one is pretty much similar to the EU, but they adapt to its local priority. When we look at the Asia Pacific, Singapore, Hong Kong, Japan, even the China, they require the different ESG approach, but most focus reporting. For the last one, the emerging markets, that is a little bit tricky. ESG is still the new and the developing. There is a growing awareness, but often in the formal regulation. This the chart to show you this global diversity and the scope of the ESG regulation. You could see that each regime they do have its own ESG regulation from the three perspective, either the mandatory or voluntary or the comply or explained. But for the North America, it's a little bit different from other regions. That one that you could see the other region most focus on this the mandatory regulation, but North America still rely on the voluntary. So that's a little bit different. But the data, because the data is only updated 2023, now the 2025, so we believe more the ESG regulation are coming. We could see that different regime, you have your own ESG regulation. That is also a problem because they will create a jurisdictional clash. It will make this company very difficult to comply this multiple reporting and the ESG regulation. Here, I just try to narrow down in what area they have the divergence. For example, the scope are different. When you talk about the EU rule, that the EU, we said that the EU not only require the EU company, also the non-EU company with the main business in EU, you also have to report it. But for other regions, other countries, they mainly only the target this the largest company or this listed company. And we also could see they have quite a lot of this the rule between this the mandatory or voluntary framework. So that's the second difference. And the third one, there's quite a lot of the reporting standards and taxonomy. For example, the UK and the EU, they both have a taxonomy. So when I compare the both, I could see they're very similar, but also the different, the big difference, they have a total view on the nuclear energy. The EU think that the nuclear energy is the high risk, but in the UK, they think it's the green energy. So they have a different view. For reporting, also this the reporting, the EU, they use this double assessment. This is a double assessment. So when they have to report, they have to consider both financial and also the impact, the materiality, the assessment. But for US, they only focus this the financial assessment. So this the different standards. And the level or the due diligence also quite different. For example, the EU, they impose human rights and the environmental consideration across this operation. But other countries, they don't have such law. And the last one, when we look at the enforcement, we count that each country, you use total different approach for enforcement. Some countries, they prefer financial fines. And some countries, they maybe use a civil director liability or the civil the fine or this the different enforcement approach. So this we could see they have quite a different divergence in the different areas in the ESG regulation. That indeed, they lead to a lot of the challenge for the company and the lawyers. For example, that this the law, some ESG regulation that have extraterritorial reach. For example, like I said, that the EU law that not only target the EU company, they also try to bring the non-EU company into the reporting. And that will be create the company, when you comply this reporting, they probably will face this multiple, even the conflicting, the reporting obligations. So for the company, in order to reduce the risk, the regulatory arbitrage, they probably will shift their operation to choose some kind of country or the region with the weak ESG the regulation. And the last one, without the cooperation, the enforcement, we all know the lawyers, we all know the cross-border the enforcement is always costly and uncertain. The second challenge is the data, how to collect the data, verify data, and make sure the data accurate is also very challenging, particularly from the supply chains in the emerging countries. The lack of this standardized data and the verification the process probably will lead all this they call the greenwashing. Greenwashing, so it means a format that exaggerate or the false the environmental claims. So we could see there is increasing the risk. That is the need for the robust audit chain and the independent assurance. For lawyers, this dynamic regulatory environment also create a huge demand for the lawyers, particularly for the lawyer in the comparative ESG expertise. From this compliance assessment to the due diligence and the ESG regulation drafting, contract drafting, or the dispute. There are many, many ways the lawyer could add the value in the ESG. We could see there is a risk, and also they have present a huge opportunity for the lawyers to advise this best practice and the risk mitigation. Second, the ESG is also central to the cross-border transactions. And whatever from this the M&A, project finance, and also the cross-border deals. Investor, the company, they want to know more about the ESG, the risk, and the opportunity tied on their targets. So they want to know that is the present a huge opportunity for the lawyers. You could help them to structure the transaction aligned with the ESG goals. And also for the lawyers, we could advise on some kind of green finance, green bonds, or sustainable financial instruments. Conclusion, we could see that ESG, the regulation, whatever you like it or not, is the involving regulatory with the increasing the complex or the global impact. Significant challenges exist, but also substantial opportunities for the legal professionals. The key for us is have to stay informed, develop specialized expertise, and see the collaboration. With the right approach, we could reshape a sustainable and legal sound future. And thank you.
Thank you very much, Flora, for your very insightful sharing. Flora, I think your presentation really brings to the fore the challenges that lawyers are facing today. You know, not only do we have to grapple with new tools like technology, some of these new areas of practice, like ESG is a relatively new practice for lawyers, compliance is a new practice area, but a lot of the issues are quite similar, a lot of cross-border questions, a lot of interoperability questions as well. So thank you for really focusing our attentions on the issues. I'd just like to turn the time over now to Faizullah, partner at Denton's International Law Firm, to share his perspective on the future of advocacy in the digital age. But just before you get started, just a bit of housekeeping. Unfortunately, I don't think we'll have time for Q&A today because we started late. So please keep your questions for lunchtime with the speakers. And if I can just ask the audience to indulge us till 1 p.m., that would be very appreciated. So, Faizullah, over to you.
Thank you. So, good afternoon, everyone. It's a real honor to take part in the 4th Tashkent Law Spring International Legal Forum, together with such a diverse international group of panelists. Today, I would like to discuss how digitalization is changing the rules of the game for the legal profession. The emergence of AI is a technological revolution, and it's transforming many industries in the world, including the legal services industry. According to the global tech market research, the legal tech market surpassed 35 billion USD, and more than 60% of large firms are already adapting generative AI tools into their workflows. These numbers clearly indicate that the effect of digitalization on the legal profession is not a forecast, but our present reality. Throughout my speech, I'll be talking about how digital era is reshaping the legal landscape, examine some new legal digital tools, discuss a rise of new generation of lawyers, address the challenges that come with the legal digitalization, and explore the future of the legal profession. So we'll start with the changes in the legal landscape. There is certainly a shift from the traditional lawyer as a consultant approach to lawyer as a trusted advisor, strategist, analyst, and innovator from the side of the client. Because the clients now come with these new expectations. The clients, whether corporate or individual, now demand faster turnaround times. They want real-time updates. They want greater predictability in pricing and seamless digital experiences. The reason behind this, I believe, is because their businesses are also changing, and they are often under pressure to lower expenses against responses to their legal needs as soon as possible. As a result, businesses are getting what they need, but not from traditional law firms, but from alternative legal service providers and legal tech platforms. You can see on the slide a number of those. So an Ironclad is a company that provides a platform that tracks contract life cycle throughout its existence. Do Not Pay is an AI-driven platform which serves as a digital advocate, which helps users to tackle unfair parking tickets and cancel unwanted subscriptions. And Garfield AI is a separate new thing that happened recently. It's a first AI-only law firm which has been approved in the UK by the Solicitors Regulation Authority. Garfield AI reclaims unpaid invoices and uses AI to simplify small claim court process. These platforms are lowering the barrier to entry for legal services and challenge the traditional legal services model. So what can we do as lawyers in this situation? We need to adapt the new legal digital tools, since adaptability is key to thriving in such a challenging legal landscape. What we can do as lawyers, we can use tools for automation, tools which help transform time-consuming manual work into automated process. One of the examples in our company would be full automation of creation of companies' charters and other standard registration documentation. Tools can help with e-discovery. E-discovery tools help with review of large, copious amounts of data, and they allow to pinpoint relevant documents, flag sensitive information, and also identify certain patterns which lawyers, when reviewing manually, might actually miss. Next is AI-powered legal research tools which help finding relevant precedent statutes, not just through keywords, but through client-friendly requests. And last but not the least are generative AI platforms. These platforms, they assist lawyers with drafting, contract analysis, legal research, and even answering complex legal questions. What these digital tools help the lawyers with? By streamlining time-consuming tasks, AI enables lawyers to focus on higher value legal work while improving accuracy and productivity. In essence, technology enables lawyers to do more of what really matters. Now I would like to talk about some of the digital tools that we use at Dentons. First would be a Harvey AI. So this is a generative AI. We use Harvey to provide legal alerts based on new regulation that emerges in Uzbekistan. We also use it to provide draft case-specific emails with references to contracts that are being reviewed. Harvey AI also helps transcript audio to text, provide executive summaries for large reports, and for an example, LDD reports. I know of a case where a 200 pages long report was summarized in less than 5 minutes, so which is quite impressive. And one of the ways that we like using Harvey AI is for knowledge management, because we as lawyers often sometimes get similar requests. So what we can do is we can use previous deliverables, and Harvey AI helps to shape them into new client requests. One may say that some widely available free generative AIs can do the same, so why would we go to Harvey and pay for the license? Well, unlike widely used AI tools, Harvey AI actually maintains data privacy and security. Basically, it's a vault, and you won't get some information that is not relevant to your case. While using AI tools more actively at Dentons, we thought about other possible ways of introducing AI-driven services for our teams. As a result, we have launched Daisy, an internally developed by Dentons AI tool which provides secure and adaptable generative AI capabilities to all Dentons personnel. So at this first release, Daisy assists us with document summarization, drafting, and translations. For an example, yesterday I used Daisy to prepare a court decision summary, which was in Uzbek language. It prepared a summary in English language in less than a minute. This task would usually take a junior lawyer at least 20 minutes to prepare. I strongly believe that leveraging such AI tools will enhance our productivity and enable us to deliver even higher quality legal services. While we just went through some of the AI tools which were prepared by businesses for businesses and internally developed ones, I also wanted to touch upon LexAI. The launch of LexAI chatbot by the Ministry of Justice in Uzbekistan in December 2024 is an example that the Uzbek government and the ministry is taking AI legal tools seriously. LexAI serves as a legal assistant by providing answers to various legal questions, and they base their responses on national legislation database. It is expected that in the future, LexAI will also be able to develop contract templates, applications, and other legal documents. Now, we discussed some of the digital tools that lawyers can do. But it's also important to say that as legal teams are adopting digital tools, the nature of legal work is rapidly changing as well. And what we can see in the world now, the rise of so-called T-shaped lawyers. These are the professionals who combine legal expertise with the working knowledge of technology, project management, and data analytics. So some of the examples of these lawyers would be a legal engineer who might design workflows that automate NDAs for the sales teams, a legal operations specialist that might build a dashboard that tracks litigation status across jurisdictions, or a data-fluent lawyer which might cooperate with compliance team to build a model for identifying ESG-related risk in supplier contracts. The shift in skill set is not theoretical, and it's happening now. And the most competitive legal teams are already embedding these capabilities into their structure. But as legal teams gain new capabilities, they also face new risks, legal, ethical, and technological. One of the biggest risks is regulatory lag, because law often trails behind technology. So when we look at AI-generated advice, and if it's wrong, who is responsible? Is it the software vendor? Is it the law firm that's been using it? Or is the client himself that used AI-driven solutions to receive legal opinion? Due to the fact that emergence of AI may pose risk to privacy and other efforts, a lot of efforts establishing a legal framework governing AI has been initiated around the world, also in Uzbekistan, and in April of this year, Legislative Chamber of Parliament has passed in the first reading a draft law aimed at regulating the use of AI. The proposed legislation introduced a formal definition of artificial intelligence. It outlines key directions of state policy in this domain and establishes general principles for responsible AI use. Ethics and bias is another challenge and another concern. AI tools, they learn from historical data. So what if this historical data has bias inside of it? So we have already seen some cases when, when some of the sentencing models have been called out for racial bias. So what happens if similar tools are used to assess litigation risks? So this is another challenge. And of course, cybersecurity. We as lawyers, legal teams, we handle a lot of confidential data, IP, personal information, trade secrets. And as our work becomes more digitized and more cloud-based, we also become more exposed. And this is something that we need to keep in mind. So the legal professionals must not only adopt tech, the lawyers must also do so securely and ethically. So now I would like to talk about the role of lawyers in shaping the future. So basically what we can do. And here, I believe that addressing the risks isn't just a necessity, it's a call for a legal profession to take an active role. And we have to decide what would be our role. So are we cautious adapters who are always a step behind technology? Or we can be co-creators of the digital legal future. The ministries of justice can lead by modernizing regulation, enabling cross-border digital cooperation, and supporting legal innovation sandboxes. In-house legal teams can work with their IT and product teams to provide new solutions internally. Law firms can reimagine the service delivery in general, not just digitize the old model to become more client-centric. The legal leadership should provide and encourage the use of new digital tools, as well as appropriate training for their teams to do so safely. The tools are here, but the mindset shift is what matters the most. So allow me to conclude with the following thoughts. Technology won't replace traditional lawyers, but tech-savvy lawyers just as might. Change is the only constant, a saying attributed to the Greek philosopher Heraclitus, who lived in 6th century BC, at this moment is more relevant than ever. Let's not wait for change to happen to us. Let's lead it with integrity and a clear vision of what legal profession can be in the digital age. Thank you.
Thank you, Feyzullah. That was a really expert analysis of the overarching landscape that law firms are facing. I think my key takeaway here is really, it's client demands that are changing the landscape, and it's really forcing lawyers to be able to adapt. And the new tools that are available to lawyers, clients are expecting us to use that. And with all of that, we also require a mindset shift to be able to be effective in this new landscape. Thank you, thank you. And with that, I'd just like to shift gears a little bit to going back to the leaders of the legal profession. We've got Mr. Han Yong-an, who is the Vice President of the All China Bar Association, who'll be talking about digital technologies to expand legal services, specifically looking at the context of the One Belt, One Road initiatives. So, Han 先生，你可以开始吧。
尊敬的各位领导、各位嘉宾、各位女士们、先生们、朋友们，大家下午好。很荣幸参加第4届塔什干法律之春国际法律论坛，与各位共同探讨技术浪潮中的法律、律师、数字化的角色和作用这样一个重要的话题。近年来，我们通过数字技术 打造一站式法律服务平台和促进国际化的协同方面取得了一定的进展。在享受技术创新的不断进步带来的便利化的同时，面对数字化建设和人工智能的发展，在全球领域给各个行业所带来的深刻影响，我们律师同行们同样面临着诸多挑战和机遇。今天啊，我想从全球法律科技创新所引发的趋势出发，结合中国与“一带一路”共建国家的实践经验，与大家分享以数字技术创新拓展法律服务边界，共同协同共建“一带一路”法律服务的新生态这样的话题与大家进行交流。首先，从全球的趋势性来看，法律科技创新正在拓展传统认知的边界。提到数字技术创新，人工智能作为大数据时代下最热门的概念，正在重构者的身份席卷全球法律服务。那么这场时代变革在法律行业所呈现出的主要趋势有如下几点：第一，它从人力密集型到智能驱动型提升效率的转变。目前我们已经能够利用人工智能工具，快速准确地进行法律检索、法律法规、案例等等信息，提高检索的效率。诞生在1985年北京大学法学院的查询软件，已经经过了40年的不断的改进和积累，现在能够利用智能算法，在瞬间定位相关的法律法规以及类似的案例。如今，中国的人工智能模型已经具备了自然语言的处理、逻辑分析等基础性能力。借助法律垂直领域的模型库，人工智能得以实现自动审查合同文本、条款，识别潜在的法律风险，对不一致性的条款和法律条款漏洞进行排查。在实践当中啊，我们有一部分法律从业者已经开始借助人工智能辅助审查合同的条款。那么这些技术变革呀，正在逐步地改变着传统法律服务的提供方式，同样也正在改变着人们对传统法律服务提供的理解。第二个趋势关于让法律服务触手可得，实现更好的普惠化。随着群众法律服务日益增长，传统的公共法律服务模式已经暴露出了它的低效率、成本高、质量参差不齐这样的一些问题。那么人工智能技术的兴起，带来了 AI 律师这样一个普惠化的法律服务，它可以有效地缓解欠发达地区法律服务律师资源欠缺的问题，也为老百姓带来了便利。比方说，我们中国的一个地级市司法局，它探索掌上的公共法律服务平台，接入 DeepSeek 大模型，对法律服务的自助终端进行人工化的职工升级，也通过人工加司法的一些概念来深度融合，构建了线上和线下的协同、人工智能互相补充这样的一种新型的诉讼服务模式。第三种趋势是在寻求创新与监管之间寻求平衡这样的一种挑战。从更大宏观的层面来看，在人类文明发展到历史当中啊，我们一直在面对着技术革新与新规则管制之间的不断博弈。比如说，有一些律师在用人工智能服务当中，他比方说在移民的案子当中用了人工智能 AI 的生成法律文书，但是在提交的法律文书当中呀， 也出现了虚拟的10几个虚拟的案例。那么这样的错误呢，应该说我们律师通过经验的预判，对技术创新的出现错误要予以包容。然而在法律行业呢，真正的可靠的挑战是不允许包容，也就是要有律师的识别和纠错。这也就启示我们在人工智能的幻觉效应当中，可能会引发职业伦理危机。那么，欧盟的人工智能法案将法律 AI 的系统性列为高风险领域，要求训练数据的透明化、决策过程的可溯源。在迪拜的国际金融法中心法庭呢，规定了 AI 所使用的法律文件要标注有机器辅助这样的标识。在现有的实务当中的经验也告诉我们，任何技术创新都不能离开监管，那么人工智能也不能例外。在法律和行业的应用当中，更应该关注这样的话题。第二个方面是关于未来之路，包容、共赢和协同共建。面对大数据时代、技术浪潮，我们需要始终认清，数字化创新所带来的新的好处，并非所有。人工智能也并不能代表或者代替人类所通过理论学习和实践经验所积累的专业经验，特别是在法律服务领域。那么，我们也相信，数字化技术在法律服务领域出现的，并不是掀桌子翻牌，即便是在法律科技应用正在突破传统的认知边界方面，其所做的势必会让我们大家更加强大。正如在“一带一路”倡议所秉持的包容精神，我们一定是以积极的态度，要拥抱数字化技术所带来的变革，以辩证的视角看待和应用创新对法律服务所带来的体系性影响，以科学的理念协同共建“一带一路”法律服务的新的生态。基于上述认识我认为有3个方面值得我们坚持。第一个方面的坚持是坚持以人为本，要厘清人机之间的协同边界。数字技术创新的宗旨，它是以提升生产效率、服务人类文明的建设。那么 AI 的本质也是便利性的应用工具，而不应该是替代人类的智力。我们律师的核心价值是在于专业的判断、价值权衡以及人性化的沟通。如若我们一味地强调创新，倚重工具，不加思索地利用工具操作一切，那么对法治社会的建设乃至人类社会文明的延续将会是舍本逐末。社会越发展，我们越是应当清晰地以人为本的基础为原则。在数字化技术加速发展社会时代，应该确立 AI 辅助、检索、律师决策担当这样的一个原则，主次分明，最终让技术创新做加法，让律师做减法或者做乘法，使得效率和责任更大化地进行并行。第二，坚持规则先行，推动协同治理。为了保障数字化技术应用的安全和可靠，应当建立“一带一路”法律数据库和高效、便捷的、安全的数据跨境流动机制，以实现共建国家的判例、法规互联互通，使数字化技术的应用基础真实可溯源。同时，各国还可以整合各方面的力量，分别形成统一电子证据的认定、跨境在线听审程序的标准，并且通过严格的技术审验和审核机制，定期对法律工具进行评估或者更新。第3个方面，坚持系统共建，培育复合性人才。 数字化技术应当以服务人才，而非替代人类。那么，如果应用科学技术发展，培养高素质法律人才，是我们始终要回答的一个核心的问题。那么，未来的国际律师和涉外法律服务人才，它必然是法律加语言加科技这样的一种3维度的复合性人才。我们计划在中国西安示范区设立涉外法律科技实验室，联合高校、律师事务所、科技咨询公司共同开展联合培训，推动“一带一路”沿线律师事务所建立人才交换互访机制，让青年律师身处更广阔的交流实践平台，让青年法治人才掌握更为先进的工具，促进社会进步。我们所处的技术创新层出不穷的一个伟大时代，每一次的突破或许都会改变当下处于舒适圈的运行规则，但这不应当是我们拒绝前进的借口。展望未来，包容共赢更需要以人为本，驾驭法律科技的创新成果，以规则体系界定技术创新的合理性应用，科学地提升高质量人才在技术化、科技化、数字化时代的应用，提供法律服务的效能和质量，协同“一带一路”法治建设协同致远。以上是我在本次论坛的分享，谢谢大家。
Thank you.
Thank you. Thank you very much, Han Jensen, Mr. Han. I really appreciate that the Vice President of the All China Bar Association is thinking about putting people first, again, going back to the theme that was raised during our plenary session, that as lawyers deal with this changing landscape of new technology, of complex new practice areas such as ESG and climate justice, that our leaders in the bar associations are looking forward, casting the vision for the profession to move together in a way that we can have sustainable and inclusive growth. Just one more comment, and I agree with Mr. Han that technology will never replace lawyers. Before joining the Asian Development Bank, I used to work for LexisNexis, which is a legal technology company, a legal database, and I could see firsthand how our technologists and product team was using generative AI to build the next legal research tools and solutions. And the more they worked with the technology, the more that they knew that lawyers will always be a key, you will never get rid of the human. You will always need a human lawyer to work with the technology. So thank you, Mr. Han, for your presentation. And now finally, I'd like to turn the floor to Abdullah Sadiq, who is managing partner of his own law firm. And I'm very interested to hear how you are implementing AI and thinking about the AI practice for law firms in Uzbekistan. Over to you.
Thank you. Assalomu alaykum, hurmatli qatnashchilar. Men nutqimni rus tilida qilganligimga birinchi navbatda uzr so'rayman, chunki xalqaro konferensiyaligi hisobiga men rus tilida tayyorgarlik ko'rdim. В первую очередь, позвольте выразить благодарность за такую возможность выступить здесь спикером по столь важной теме сегодняшнего развития, трансформации юридической профессии. Ну, банально уже превращается вопрос, заменит ли юриста, значит, AI, либо юридические технологии. Ну, я тоже имею свой взгляд на этот вопрос и могу сказать, что нет, не заменит, заменит тех, которые, те адвокаты, юристы, которые используют AI и юридические технологии, заменит своих коллег, которые не используют в своей практике. И вот мы вот сегодняшний день уже стоим на пороге такой масштабной трансформации юридической профессии. И согласно последним исследованиям Thomson Reuters, 79% юристов уже ожидают высокого влияния искусственного интеллекта на их работу к 2030 году. Важно тут понимать, искусственный интеллект – это не угроза нашей профессии, а мощный инструмент усиления наших возможностей. На сегодняшний день в Узбекистане такие проводили, значит, исследования из мирового сообщества юристов, и в Узбекистане за последние годы намечается такая тенденция развития, омолаживания адвокатуры, где требуется практика новым юристам, как раз-таки legal tech технологии как раз-таки служат для того, чтобы их быстрее ускорить это развитие. И статистика показывает, значит, один адвокат в Узбекистане приходится на 8 тысяч населения. И это и служил основанием и поводом для того, чтобы мы в Узбекистане одними из первых, значит, разработали и внедрили в Узбекистане свой Legal Tech Smart Lex. Это было, значит, таким прорывным этим, но поскольку формирование потребностей в первую очередь нужно было сделать, мы знали, куда идем, шли и полностью всю базу юридическую, значит, за 15 лет опыта нашей фирмы, значит, собрали и автоматизировали все процессы, внедрили туда AI-инструменты, которые позволяют быстрее ускорить, значит, анализ документов и даже напишет вам исковые заявления. Это сегодняшний день революция в юридической практике уже началась, и те, кто адаптируется первыми, значит, получат значительное конкурентное преимущество. Мои коллеги выше уже говорили много о тенденциях развития в мире, значит, в частности, коллеги из Дентонса, поэтому я пропускаю некоторые моменты, чтобы не повториться. Специализация решений в основном сейчас ориентируется на контрактное право, в частности, SmartLex также, CLM, то есть Contract Life Cycle Management, то есть управление жизненным циклом контрактов, и M&A транзакции, и интеллектуальная собственность, патентное право, судебное представительство и анализ прецедентов. Корпоративное консультирование и комплайнс-систему. Вот основные эти аспекты, значит, по исследованиям показывают, что они охвачены в большей степени юридическими технологиями. Одним из решений, локальными решениями является наша платформа, где инструмент контрактного права и управления юридическим документооборотом ориентированы на адвокатскую и корпоративную практику. Платформа использует искусственный интеллект для анализа договоров, выявления рисков и автоматизации процессов. Сегодняшний день трансформация эра трансформации юриспруденции, 79% юристов в западных странах ожидают высокое влияние и на их работу к 2030 году. И это во всем мире так. Искусственный интеллект, инструмент усиления, значит, они замены, я уже как упомянул. Революция в юридической профессии уже началась. Трансформация сегодня, как мы уже второй день здесь говорим об этом, она уже началась, и мы все убеждены в этом. Ключевые тенденции, каковы ключевые тенденции на сегодняшний день? Это быстрое внедрение генеративного искусственного интеллекта. 90% западных стран корпоративные юристы, значит, уже внедрили в свою юридическую практику legal tech инструменты. Рост инвестиций в legal tech, как уже выше отметили, значит, более чем 30 миллиардов долларов. То есть активно все финансовые инвесторы, то есть влияют, то есть, вкладывают деньги, поскольку там полную аналитику провели и, ну, сами понимаете, не зря там вкладываются. Специализация искусственных интеллектов, значит, решений для конкретных юридических задач, специализация идет, таких как, вот я уже упомянул, контракт-менеджмент и эти. Новая роль сегодняшний день, значит, в трансформации, это, ну, стратегический советник, то есть интерпретация результатов искусственного интеллекта и принятие ключевых решений, архитектор решений, то есть постановка задач для искусственного интеллекта и контроль качества результатов. Нам важно уметь, значит, как правильно поставить промпты и задачи, то есть, чтобы добиться большего результата от искусственного интеллекта. эксперт по этике и соответствию. Здесь обеспечение соблюдения профессиональных стандартов. То есть мы должны соблюдать профессиональные этические стандарты по конфиденциальности. Вот, там важно учитывать баланс между риском потери данных клиентов, что нам грозит, значит, дисциплинарной ответственностью за разрушение адвокатской тайны. Значит, формирование новых компетенций. Значит, современный адвокат должен развивать, значит, технологическую грамотность, в том числе наряду с юридическими экспертностью. И это включает понимание принципов работы искусственного интеллекта и ограничений, навыки эффективного взаимодействия с искусственным интеллектом и системами, способности критически оценивать результаты машинного анализа. Ну, конкретные преимущества. Здесь экономия времени, в первую очередь. До 4 часов в неделю, значит, экономии на рутинные задачи на одного юриста приходится 60-70% ускорения процессов исследования и подготовки документов и 40% повышения точности анализа документов и выявления рисков. Финансовые показатели. Значит, возможность на сегодняшний день, это статистика западных стран, генерации до $100 000 дополнительного дохода в год за счет высвобождения времени. То есть это учитывалось, значит, крупные компании, адвокатские и консалтинговые компании. 25-30% снижения операционных расходов. 50% сокращения времени на due diligence процедуры. Практические применения. Автоматизация создания и анализа документов. Это системы вроде Harvey, как упомянули выше, AI могут анализировать 1000 страниц контрактов за минуты. И, в частности, локальной платформе SmartLex тоже позволяет юристу автоматически формировать договор и из юридически выверенных шаблонов отслеживать несоответствия в тексте и получать подсказки по рискам. Такие решения дают экономию десятков часов в месяц и минимизируют человеческий фактор в типовых процедурах, в частности, ошибки, которые допускаются очень часто. Прогнозирование исходов дел – это платформы Lex Machina, анализирует исторические данные судебных решений. И вот эти топ-инструменты, Co-Counsel от Thomson Reuters, используют естественный языковой поиск, значит, нахождение релевантных дел на основе фактологического описания ситуации. То есть вы фактически кейс, либо ситуационные кейсы, значит, если будете правильно описывать, то Co-Counsel, значит, вам релевантные кейсы находит и по ним резюмирование делает. Автоматическое выделение ключевых юридических принципов. LexisNexis считается топовым на сегодняшний день по аналитике, значит, которые интегрированы и искусственный интеллект в традиционную правовую базу данных. Риски и этические проблемы. Значит, в первую очередь, как уже упомянули выше, там сказали, галлюцинации искусственного интеллекта, мы все сталкиваемся с этим. Одна из наиболее серьезных проблем – способность искусственного интеллекта генерировать правдоподобную, но фактически неверную информацию. В большей степени, когда мы используем чат GPT, либо Cloud используем, мы сталкиваемся с такой проблемой, когда ссылается на какую-то норму закона и указывает, что это Узбекистана норма, значит, статья такая-то, такого-то закона Республики Узбекистан. На самом деле, мы, если вот найдем, это окажется, что это российское законодательство, и статья тоже так же. Вот мы в своей практике, что это для этого, какую меру предприняли, мы его ограничили. То есть внедренный API, значит, искусственного интеллекта, мы его ограничили именно с своей базы. Мы, которые вводим каждый раз базу, обновляем, туда только мы направили. Вот таким образом смогли, я думаю, что сократить на определенную процентную ставку, значит, этот риск. Конфиденциальность и защита данных. Вот здесь стоит отметить, что конфиденциальность, да, во всех платформах существуют риски какие-то, в особенности, которые мы в частном порядке используем, значит, чат GPT, допустим, даже включая плюс пакет, в нем ваши данные используются для обучения модулей по умолчанию. То есть они для обучения используются, то есть платформы. А в корпоративных тарифах чат GPT вот эту функцию они обезопасили, там, конфиденциальность данных ваши, в принципе, не будут поводом для обучения, то есть предметом обучения самой платформы. Вот там отличия имеются. Но мы, в свою очередь, здесь при локализации сервер установили на себя, и поэтому в Узбекистане уже сервер наш находится, и используем корпоративную модель. Вот как раз-таки таким образом мы решение нашли. Чрезмерная зависимость от искусственного интеллекта – это риск атрофии аналитических навыков юриста. Мы уже сами испытываем эту проблему, поскольку мы уже достаточно, значит, склонны к тому, чтобы сами не думать, но в большей степени для того, чтобы анализировать и критическим мышлением подойти к этому вопросу, если то это будет правильно применение искусственного интеллекта. Потери способностей к независимому критическому мышлению тоже именно оттуда и исходят. Снижение глубины понимания правовых принципов. То есть здесь тоже принципиальные, фундаментальные правовые основы имеются, да, в конституционные и других законодательных актах закрепленные. Там тоже есть ряд таких проблем, которые могут нас ожидать. Этические вызовы – это алгоритмическая предвзятость, особенности, когда система может воспроизводить и усиливать, значит, исторические предрассудки. И при галлюцинации поисковых тоже, да, в Америке мы слышали, недавно адвоката оштрафовали на $5000 из-за того, что он неправильные кейсы привел, которые взял из чат GPT, допустим. Вот такие моменты есть в уголовном праве, значит, семейного права, здесь в контексте семейного права также и трудового права, дискриминационные практики. Прозрачность и объяснимость. Многие системы искусственного интеллекта работают как черный ящик, что создает проблемы. Невозможность объяснить клиенту логику принятия решений, может быть, сложности в обосновании позиции перед судом, вопросы профессиональной ответственности за результаты искусственного интеллекта. Правовое регулирование тоже очень важный вопрос, пока в Узбекистане еще нет регулирующих норм искусственного интеллекта, а вот в Евросоюзе имеется хартия, но и то этическая хартия, значит, пользование искусственным интеллектом. Американская ассоциация юристов тоже выступила рекомендациями по использованию искусственного, включающей обязательность понимания юристом принципов работы использованных искусственным интеллектом, необходимость проверки всех результатов, требования к обеспечению конфиденциальности клиентских данных. Это в большей степени все эти аспекты относятся к этическим. Европейский Союз разрабатывает специализированные стандарты для ИИ в юриспруденции. Практические рекомендации, то есть рекомендации у нас поэтапная стратегия внедрения, то есть автоматизация рутины в первую очередь. Что мы рекомендуем, как применять искусственный интеллект и Legal Tech в вашей практике? Начните с наиболее стандартизированных задач, каждодневные стандартизированные задачи, внедрите искусственный интеллект для поиска и анализа документов, автоматизируйте создание типовых договоров и писем. Но мы уже пользуемся этим по CLM, Contract Lifecycle Management, значит, электронная подпись, где мы внедрили также встроенный алгоритм для анализа рисков и шаблонного драфтинга контрактов. То есть платформа наша, значит, в большей степени может даже вам перевести за 1 минуту, значит, билингвально, значит, на 2 или на разные языка, там 40 языков у нас внедренные, и можете подписать документы там, и там анализ рисков. То есть вы можете подать свой договор для того, чтобы он анализировал на риски, там, в завтрашний день в суде у вас какие-то могут ли быть проблемы, если при подписании данными условиями эти договора. Аналитические функции. То есть здесь практическом рекомендации по этапной стратегии внедрения. Вторым является этап аналитические функции. Используйте искусственный для анализа судебной практики, внедрение прогностических инструментов для оценки рисков, автоматизируйте... One minute, please. 1 minute.
1 minute. Okay, great. Thank you.
Критерии выбора искусственных интеллектов, технические требования. В основном, какие эти надо выбрать. Здесь, значит, соответствие отраслевым стандартам безопасности, в первую очередь, возможность интеграции с существующими системами, масштабируемость и производительность. А правовыми требованиями являются соблюдение требований конфиденциальности, прозрачность алгоритмов, возможность аудита, соответствие этическим стандартам. Простота использования и обучения персонала должна быть, потому что, сразу же я говорю, отторжение начинается, когда вы в своей компании начинаете внедрять такую технологию. Здесь в заключении могу сказать, стратегические функции и искусственный интеллект как инструмент усиления, а не замещения, баланс инноваций и рисков, то есть вы балансируете между использованием новых возможностей и управлением сопутствующими рисками. Это включает техническую осторожность, этическую ответственность и активное осознанное освоение, то есть вы не полагаетесь на 100%, вы развиваете у себя критическое мышление. Уважаемые коллеги, мы уже стоим на пороге новой эпохи юридической практики. У нас есть уникальная возможность стать архитекторами этого будущего, а не его пассивными наблюдателями. Давайте вместе создадим это будущее, где технологии служат справедливости, а человеческая мудрость направляет цифровую силу. Спасибо вам большое за внимание.
Thank you. Thank you so much, Abdullah. I really appreciate this. Is the perfect speech to round up our panel. And I think one of the things that really stood out to me is how much the legal technology industry is developing. You've got some really good numbers there on how we're using this technology. But at the same time, there's a lot of risks. And the last question I want to just pose to everyone as we move off for lunch to tie everything all together is, as our legal profession goes into new and challenging practice areas like ESG, when we've got new tools to navigate, how do we remain human-centered for the next generation of lawyers? I think all of us in this room who are practicing lawyers, we're not going to practice forever, and I don't think we want to. But how do we make sure that our junior lawyers are going to be equipped to be as good as we are, or even better, to maintain the rule of law and to uphold justice in the wave of technology? So please join me again in thanking our panelists. And I'd like to thank the government of Uzbekistan and the organizers for this great session, and thank you for the interpreters as well for helping with our understanding. You're all adjourned for lunch. Thank you. Thank you. 先生，谢谢，我真的很
Раз, два, три, четыре, пять, шесть, семь, 10. Два, три, четыре. Раз, два, три, четыре, пять, шесть, 10. Раз, два, три, четыре, пять, шесть, семь, восемь, девять. 4, 5, 6, 7, 8, 9, 10. Раз, два, три, четыре, пять. 7, 8, 9, 10. Раз. Раз, два, три, четыре, пять, шесть, семь, восемь. Раз, два, три. Громкость. Когда их включают, 3 секунды задержка. Хорошо, а этот последовательный спикер, это панель?
И.
Hello. Don't touch. Don't touch. Okay, thank you.
Okay.
So, dear panelists, do not touch the microphone. Do not switch off.
Okay.
Minutes? 12 to 15. 12 to 15. Professor Raimundus, we are waiting.
Calisthenics.
Professor, Ya özü olti talikdi. Özü olti talik. Hello. Nice to meet you. I will just send a gesture.
Okay. But I think that we will do similar time.
You are the last one.
Okay.
And the best.
The last. It will be the
How are you? Listen, I'm
Very
going to
tired.
go quick.
Today in the morning I did another my speech in this ad hoc in the youth legal form.
Okay.
Хорошо, все, спасибо.
Assalamu alaikum. Dear participants, we are approaching to start, so we kindly ask you to have your seats, please. We have 1 minute, yes. Assalomu alaikum, hurmatli forum qatnashchilari, aziz mehmonlar. Good afternoon, dear honorable guests, respected professors and esteemed participants. It's my great pleasure to welcome you on our today's session on legal education 4.0, new competences, technologies, and challenges. And I'm delighted to be a moderator in this particular panel. Our panel will focus on 3 main questions. The first question, why we need digital transformation in legal education. The second question is how to do the transformation more properly and effectively. And third question, what we have to do to make this transformation in an appropriate way. So to emphasize the importance of the topic, I would like to emphasize that as digital innovation continues to reshape our society globally, legal systems face unprecedented challenges and opportunities. And this legal transformation requires us to rethink and adapt legal education, ensuring that future legal professions are equipped not only with traditional legal knowledge, but also with technological competences and critical thinking skills necessary to navigate the complexities of the digital age. So today's session is designed to address these important challenges. We'll focus on how digitalization reshapes core legal competences and explore new pedagogies and tools that prepare legal professionals for the future. Our discussion also will emphasize the importance of collaboration between legal experts, technologists, policymakers, to build responsive legal framework aligned with evolving digital landscape. Accordingly, our session will consist of 2 parts. In the first panel, we'll focus on core legal competences and digital skills those we need for future legal career. And in the second panel, after coffee break, we will talk about utilizing innovative tools, platforms, and AI in training of legal professionals. I would like to highlight that it's a privilege to have such a gathered distinguished panel who are leading experts from around the world who will share their insights how legal education can innovate and evolve to meet the demands of the digital era. Without further delay, let me introduce our first speaker. One of those leading specialists, Professor Simon Thompson. He is a Deputy Pro-Vice Chancellor International and Head of School of Education and Social Work at Sussex University in the United Kingdom. He has subsequently taken on a number of leadership roles, including Director of Initial Teacher Education, Head of Education, and Deputy Head of School. Besides his excellent leadership, he also continues to engage in teaching, supervision, partnership, and scholarship activities in education and social work. He will give a speech on what professional knowledge and pedagogies do legal educator needs for digital age. So please welcome Professor Simon Thompson. Professor, the floor is yours.
Thank you very much indeed. Yeah, there we are. Thank you very much indeed. Thank you very much for the invitation. I am delighted to be here. And I present myself here because I was reflecting on the fact that I am not a legal educator and I have no legal training in any way whatsoever. I've only encountered a solicitor twice in my life when I've purchased a house. And I put into OpenAI how would I write a speech for legal educators about professional knowledge. And this is the speech that it wrote for me. I'm not going to read it, it's not very good. And also this is a picture of me generated by AI at your conference today. And as you can see, I don't look so well in this picture. But I wanted to kind of present myself not as an expert in legal education, but as an expert in teacher education. So I am focusing in particular on the needs of those people who will be involved in educating the future legal profession and to think about the skills that they need. And when I look around me, I see that I've got quite a lot of students here today, so it will be important for you to reflect on the kind of expectations you might have of your legal educators. And there is my prompt into ChatGPT to set up the lecture for me. So I presented it in 3 questions to consider, because I talk about a digital age, or we have been talking about a digital age. So what do we mean by a digital age, and where does that terminology come from? So first of all, I want to emphasize that this kind of concern, anxiety, excitement, need for thinking about the impact of technology has been around for a long time. There's a comic book there from the 1950s in which we've got the man with the electronic brain, and then we've got a broadsheet, a tabloid rather, from the UK, which is talking about common anxieties about the use of AI in contemporary culture. So it's everywhere. Everyone is thinking about it. We've been thinking about it for a long time. But I wanted to draw your attention to some research that I was involved in back in 2005. And in 2005, our government commissioned different universities to imagine what will education be like in the year 2025? What will it be like in 20 years' time? I will share this research with you later on, but some of the things it talked about, remember this is before anyone had a smartphone, before we had anything on our watch, before anyone had any common understanding of what AI is, it talks about some of the realities that we are facing today. Yes, we will have huge access, unbridled access to lots of information, but we will need to think carefully about how we engage with that information. So even though we didn't understand the challenge as we face it now, even 20 years ago, we were predicting some of these trends and thinking about some of the critical skills that we will need. We talk about a digital age, but actually now we might think about a post-digital age. Because the truth is that digital innovation is now part of our lives so much that we no longer question whether we would use it or not. It is there all the time, it is there in every task, and it's there in all of the classroom interactions we have and in the assessments. So instead of thinking about the digital age as if it's something that's going to happen, we should be thinking about it as a post-digital age. What does it look like when we take for granted that the digital technology is going to be there to work with us? So having set out, and there's a cartoon there from an American paper that talks about after the horse has bolted, which is a term that's used to say, you know, we can't start thinking about these things. These things are already here. We can't start thinking, how are we going to respond? Because it's happening now. And increasingly, all organizations, educational organizations in particular, have to realize that the use of AI is not something we have to legislate for, regulate for. It is happening. So we can't ignore that need. So that makes me think, what is the professional knowledge then that legal educators need in order to work with future professions? What do they need? Now, unlike the students that they will be teaching, they will not necessarily have grown up with that technology. And they maybe have able to navigate their career without engaging with that technology. So we have to think about what is the professional knowledge that the legal educators need in order to make this successful. Now, I said that I spend most of my time working as a teacher educator. And so I think about the kind of teachers that I want to work with. There's some research by Schulman and Schulman that talk about an accomplished teacher. They say an accomplished teacher is a member of a professional community who is ready, willing, and able to teach and to learn from his or her teaching experiences. And in that single sentence, they set out the kind of expectations that we might have of all higher education professionals to think about what we need to do with our students. We need to have a vision of how we want to use, for example, AI or new technology. We need to do it, we need to act upon it, we need to have the motivation. We need to know what the benefits are, and we need to learn to be able to do it ourselves. And we need to be reflective. That is, we need to keep thinking about how we might use the new technology to strengthen what we're doing. And also recognize that as legal educators, we are not alone, that we need to be part of an active community and work with others. Now, I spent many years thinking about what are the knowledge domains that we have as educators, and set it out in this model here. I want to emphasize that obviously at the top we have our subject knowledge, our knowledge of the legal systems, how that interacts, how that's applied, and that's absolutely vital. But we also need to think about how we teach it. Who are our learners? What's the context in which we're working? And what values and beliefs do we have that we bring into our classroom space? So let me turn finally then to the need for thinking about the pedagogies. How will we adapt our pedagogies to work in this new context? Now, this is before, again, AI was part of our lives. But back in 2019, there was a Durham Commission in the UK that was thinking about creativity in education, in the whole field of education. And it emphasized that most of the information we need, most of the substantive information, is readily available already. In fact, when I think about ourselves as educators, if you are a student, you can find the information out quicker, you can find it in more exciting ways, and you can use it in different ways much quicker than we are able to educate you with that information. So we have to rethink, how are we going to deliver that information to you in more creative ways and in more critical ways? The importance of that critical thinking is going to be absolutely fundamental. Now again, well before we were thinking about the use of artificial intelligence, when we just thought about using technology, researchers have been thinking about the relationship between our subject knowledge, what do we know about what we have to teach, how we teach, our pedagogy, but also what we know about the technology. And the intersection between those things has been important, but is now increasingly important that we need to be aware of it. All sorts of online technologies, new technologies that we can make use of, that have been used and referred to: online learning, flipped learning, virtual learning, distance learning. But at the bottom of that diagram, you can see the contexts, and the importance of that artificial intelligence shifts the way in which we are thinking. There's lots of advice out there. There's another Simon Thompson. I'm not the only Simon Thompson. Here's another Simon Thompson that has developed lots of different frameworks for us to use, the 4E frameworks, that talks about how can digital technologies enhance, enrich, empower. I share that with you. I've got some materials to share a bit later on. I want to emphasize that as we go through this journey together, we'll need to be mindful of some principles of ways of working. We'll need to be relational, that despite the fact that our new technologies, exciting new platforms, it will be the teacher and the legal educator who will need to navigate that for us. We'll need to be very clear about what our expectations are of our students in their own learning and in their assessments. We'll need to make sure that we recognize that some will have access to new technologies and some will have less access. So we'll need to be inclusive. And we'll constantly need to be reflective in our ways of working. So we can't do this alone. As I said, it's important to come together as a learning community. We, at my university, have done lots of work recently in thinking about our students, in being really clear when it comes to their assessments. What are our expectations? At some points, we're going to say, no AI can be used, but also, if you can see on the diagram in front of you, we'll say, yes, use AI to its full capabilities, because that's something that you'll need to be able to do. But we also want our students to acknowledge what they're doing, to describe it, and to evidence how they've used it. So in every assessment, we're getting students to reflect upon their own use of artificial intelligence. We're very lucky, we've got a great unit called Education Enhancement, which provides all sorts of resources, and I'm sharing a link with you on that. And also, we need to recognize that we need to explore this ourselves. I'm not talking to you as students, I'm sure you're already finding these things out, but for the legal educators, we do have to test out these ideas. We have to find the resources. Often YouTube will talk us through those if we can't find someone to help us. We need to test them, we need to prepare the resources, and then we need to be ready to experiment and reflect with those new technologies. So, there is a QR code there which links to a Padlet, which has references to all the research that I talked about. It shares my slides, and it also introduces you to my colleague, Verona O'Driscoll, who is an excellent legal educator, who is at the forefront of thinking about AI in legal education, and would be well worth engaging with some of her materials, which I've shared on that Padlet. Thank you very much.
Thank you, Professor, for your speech. And to frame this conversation, I would like to ask one question. So you mentioned about the creative education. So in order to explain this, can we take a balance between education and digital advancements? Like how we can keep balance between AI and teaching education methods? I mean traditional teaching education methods.
Yes, and I always have said to anyone that I'm working with, and one of my jobs at my university is to run a professional development program for new lecturers, but as well as established lecturers. And I emphasize the importance of merging the two ways of working. That what I am not suggesting, and I hope no one else would suggest, that there is no value in the traditional ways of teaching that we are used to. But we also need to recognize that that is not the only way of teaching, not necessarily the most efficient way, and we need to embrace those other ways of teaching and learning as well, including the use of new technologies.
Yeah.
They're not exclusive of each other.
Thank you. Thank you again for your speech, Professor. And Q&A session will be at the end of this session. So let me turn to our next speaker, Professor Elchin Abuzar Kalafov. He's currently serving as a Deputy Rector at the Academy of Justice under the Minister of Justice at the Republic of Azerbaijan. He got his PhD at the Institute of Philosophy and Law of the National Academy of Science in Azerbaijan and continued his academic career as Associate Professor at Baku State University. As a practitioner, has held several leading positions within the Ministry of Justice, including Chief Advisor and Head of Legislative Department. He will give his speech in Russian on training of qualified legal personnel, current states and challenges. Professor Elchin Khalafov, the floor is yours.
Mən sizi Azərbaycan Ədliyyə Akademiyası adından salamlayıram və məni bura dəvət etdiyinə görə Özbəkistan Respublikası Ədliyyə Vəzirliyinə, onun institutuna öz təşəkkürümü bildirirəm. Və icazə versəz, çıxışımı rus dilində edəcəm. Уважаемые участники форума, тема моего доклада посвящается вопросу подготовки квалифицированных юридических кадров, современное состояние и вызовы. Прежде всего, когда мы говорим о подготовке кадров, юридических кадров, и это созвучно с темой этого форума, мы должны себе представить, что оно представляет собой право будущего, какие вызовы имеет это право, на основе каких ценностей оно будет развиваться. Ценности остаются прежними. Это вечные ценности, свободы, справедливости, верховенства права. И главным вектором развития права будет его гуманизация и защита всех интересов всех слоев населения. Право, прежде всего, регулятор общественных отношений. Поэтому право, современное право, оно должно эффективно регулировать эти отношения, которое должно отвечать запросам всего общества. Но вместе с тем вы скажете, что существуют пробелы. Пробелы могут быть в законодательстве, но пробелы не могут быть в праве, поскольку, я думаю, и у нас в стране, и у вас эти пробелы устраняются путем толкования, путем применения аналогии закона, если нет соответствующего закона, аналогии права на основе общих принципов права. Эти положения закреплены в Конституционном законе Азербайджанской Республики о нормативно-правовых актах. Конституционный суд очень часто использует это, судебная система использует эти положения. Это один из моментов того, что право должно быть эффективно, и в самом праве должны быть заложены механизмы в том случае, если существуют пробелы в законодательстве. Если вместе с тем существуют споры. Существуют споры, и мы говорим об судебной системе, об эффективной судебной системе. Эффективность судебной системы, конечно же, связана с тем, что судебная система максимально кратчайшие сроки должна разрешить спор, который возникает между гражданами, между юридическими лицами. Проблема в том, что здесь только лишь в постсоветских странах есть понятие процессуальных сроков. В большей части европейских стран нет понятия процессуальных сроков. Но вместе с тем это не означает, что судебные споры могут длиться бесконечно. Мы говорим об эффективных, других сроках, в гражданском праве, соразмерных сроков, разумных сроков, в рамках которых должны разрешаться эти споры. Но вместе с тем, путем судопроизводства невозможно охватить интересы всех граждан. Кто-то в судебном процессе останется недовольным. И в этом плане вступает медиация. Кстати, медиации посвящена одна из панелей этого форума. Это очень важно, примирять стороны. Очень часто примирение сторон является в некоторых странах сами суды, сам суд может осуществить эту функцию, примирить стороны. У нас в стране есть отдельный институт медиации. Я думаю, что аналогичные структуры существуют у вас. Очень часто, если судья, если это будет наша страна, будет медиатором, то ему может последовать отвод, так как он может сторонам показаться, что он принимает сторону одной из сторон. Поэтому я думаю, что медиация – это самостоятельный институт. Как искусственный интеллект в этом плане может помочь в рамках судопроизводства? Конечно же, в большинстве из наших стран существует система электронной юстиции, которая позволяет судье составить электронный протокол, который позволяет в электронном порядке оповестить стороны о будущем судебном процессе, который поможет составить приблизительное решение суда. Вот в этом плане искусственный интеллект, конечно же, могут помочь и правосудию. Конечно же, на право будущего влияет глобализация и трансформация правовой системы. Это международные вызовы, глобальные вызовы. Здесь есть определенные угрозы для наших правовых систем. С одной стороны, это, я бы сказал, процесс бинарный. Здесь есть свои плюсы и минусы. С одной стороны, мы видим в глобализации определенные угрозы для наших правовых систем. С другой стороны, это связано с потребностями наших граждан в тех инновациях, которые несет эта глобализация. примеру, пандемия, значит, вы согласитесь, наверное, была в определенной степени, представляла угрозу для наших систем, правовых систем, и связано это было с нарушением прав человека. Наши правовые системы оказались неподготовленными к этому. И все в конечном итоге ведет к формированию и защите наших правовых систем, зарождению новейших отраслей права. К примеру, применение электронных технологий ведет к образованию и зарождению таких правовых дисциплин, как значит, киберправо, цифровое право, право интеллектуальной собственности, интернет-право. Применение технологий биоинженерии ведет к образованию таких подотраслей права, как биологическое право, геномное право, нейронное право и так далее. То есть Болонская система, которая в настоящее время применяется в нас и в большей части европейских стран, позволяет вводить учебный процесс. Эти дисциплины, они не являются основными дисциплинами, но являются выборочными дисциплинами. И я думаю, что юридические факультеты должны применять, должны, значит, вводить в свои учебные процессы эти, значит, дисциплины. Одним из которых, наверное, будет связано как раз-таки право искусственного интеллекта, связано с искусственным интеллектом и связанные с этим понятием, значит, предметы. Это как мы представляем себе право будущее и основные векторы развития будущего права. Конечно же, когда мы говорим об обучении современному праву, мы должны себе представить, какие требования мы выдвигаем современному юристу. Современный юрист, помимо того, что он хорошо должен знать теорию права, он должен обладать практическими навыками. Это один из тех недостатков, которые, к сожалению, выпускники юридического права не имеют. Практические навыки. Он должен хорошо знать проблемы своего общества и видеть выход из этих проблем и быть эрудированным специалистом. И современное требование еще он должен знать хорошо технологии, компьютерные технологии. Как мы обучаем? Два подхода. Первый, что мы изучаем и как мы изучаем, каким методом мы используем. Прежде всего, мы должны говорить о совершенствовании учебных планов на юридических факультетах, которые меняются в зависимости в странах по-разному. В нашей стране есть стандарты по специальности правоведения, которые меняются приблизительно каждые 3 года. Но вместе с тем в этих стандартах заложена идея основных и выборочных дисциплин в соответствии с Болонской системой. И выборочные дисциплины, о которых я говорил раньше, юридический факультет сам имеет право, значит, вводить в их учебный процесс. Интерактивные методики. Эта проблема связана в большей степени, может быть, сейчас с искусственным интеллектом, с применением IT-технологий. Интерактивные методы обучения праву. Для европейцев это давно звучит не новость, но для нас, допустим, постсоветских стран, в течение 30 лет, последних года независимости, можно сказать, что мы освоили эти методики, интерактивные методики преподавания права. Это ролевые игры, мозговой штурм и так далее. Всем нам известны эти методики. Доказано учеными, что, применяя эти методики, студенты осваивают большую часть материалов. На лекционном занятии, приведу один пример, 3% материала осваиваются студентами, но это мнение, оно доказано на основе, значит, разработок. Но вместе с тем наиболее значит, больше материала осваивается, когда мы чему-то учим. Это также, эта методика применяется, значит, в юриспруденции. Так какие же требования к образовательным учреждениям существуют в связи с тем, что я говорил? Ну, начнем с университетов. Большая часть юридических факультетов, они находятся в классических вузах. То есть помимо юриспруденции здесь преподаются еще другие дисциплины. Поэтому руководство этих университетов не всегда юристы, не всегда мы можем донести свое слово до руководства. Поэтому в нашей стране вузы создаются уже в форме публичных юридических лиц, и как управленческая структура здесь имеется совет попечителей. В совет попечителей входит представитель Министерства юстиции, и даже могут входить представители каких-то компаний, значит, юридических компаний даже, которые могут рекомендовать, дать свои рекомендации относительно учебных планов. Юридические клиники. Я думаю, что и в Узбекистане есть юридические клиники. Значит, основная цель – прививать практические навыки на основе бесплатных юридических консультаций малообеспеченным слоям населения. К сожалению, не во всех наших странах мы обеспечили это как составную часть учебного процесса. Все еще это выборочная дисциплина. Наиболее ярко она применяется в американских университетах, где он является, можно сказать, что обязательной дисциплиной, которую студенты должны пройти через юридическую клинику. Направления юридических клиник могут быть разные. Различные подходы имеются в Великобритании. Значит, по этому поводу, значит, по поводу этих юридических клиник, здесь не задействованы адвокаты, студентов не допускают в суды, но вместе с тем, значит, я думаю, что значит, обеспечение работы юридических клиник является одной из очень важных требований, которые улучшат юридическое образование. И, наконец-таки, разработка программ прохождения практики, которая не должна носить формальный характер. Мы говорили о том в начале моего доклада, что отсутствие практических навыков является основным недостатком для юристов, который окончил бакалавриатуру юридического факультета. Он не может опросить клиента, не может написать исковые заявления, не может составить трудовой договор. Это является основным недостатком. И более того, судебная система, прокуратура, Министерство юстиции также выдвигает аналогичные требования, и для того, чтобы разрешить эти все проблемы, они создают свои специализированные образовательные учреждения. Это академии, так называемые. В Узбекистане есть две академии, Академия правоохранительных органов, есть отдельный, значит, институт, который связан с судебной системой. Причина как раз-таки заключается в этом. Значит, есть аналогичные подходы и в европейских странах, различные модели. Германия имеет свою модель, первый государственный экзамен, второй государственный экзамен, по окончании которого, значит, уже выпускник становится судьей, прокурором, адвокатом. Наши же страны применяют эту методику. Поэтому мы, конечно же, должны совершенствовать эти программы, обеспечить, потому что и одновременно с первичным обучением в этих же структурах организовывается повышение квалификации. Повышение квалификации до нашего пенсионного возраста, как говорится. Мы должны повышать свою квалификацию, потому что право тоже, оно развивается. И в заключении доклада я хочу и подытожить о том, что все-таки какие требования и как мы представляем юриста будущего. Прежде всего, нужно отметить, что современное образование юристов оно должно учитывать основные векторы развития современного права. Оно должно строиться на основе гибких учебных планов, на основе которых могут вводиться новые учебные дисциплины. И, наконец, я считаю, что обучение должно быть концентрировано на, значит, подготовке кадров, которые имеют определенное направление, и выбирать определенное направление в праве. Уголовное, гражданское, административное. Система образования должна это позволить. Это все, что я хотел сказать. Я хочу благодарить вас за внимание. Спасибо.
Спасибо за содержательную презентацию, профессор. Вот, в своем докладе вы несколько раз упомянули о право будущего. Вот, у меня такой вопрос. Что является основной отличительной чертой права будущего? Все-таки это технологии или есть другой, иной, как основной элемент? Спасибо.
Спасибо. Прежде всего, я хочу сказать, что мы не должны ждать от права какие-то предсказания, какое будет будущее. Скорее всего, право всегда отстает от тех реалий, оно всегда догоняет, хотя должно быть наоборот, потому что право, оно консервативно, его сложно менять. Но вместе с тем, налицо, что технологии, конечно же, будут влиять на право, и мы сами в этом убеждаемся. Конечно же, я считаю, что искусственный интеллект не может осуществлять правосудие, не будет осуществлять правосудие, но вместе с тем искусственный интеллект будет помогать осуществлению правосудия. Он может, значит, подобрать какие-то решения, посоветовать судье, значит, относительно проекта решения, но не выносить такого рода решения, потому что у него, наверное, как говорят, не хватает души для этого. Вот такое мое мнение. Спасибо большое.
Спасибо еще раз за ваш доклад. Our next speaker, Professor Kei Hirota and Yasuhiro Miyake-sensei from Japan, they will give speech on the use of AI in legal technical cooperation and innovative methods of teaching and research in legal education. Let me introduce them briefly. Professor Kei Hirota is currently working as a professor and government attorney at the International Cooperation Department of the Research and Training Institute under the Ministry of Justice of Japan. He used to work as a public prosecutor in Tokyo, Fukuoka, Yokohama, and Yokkaichi branch of the Public Prosecutor Office. He also served as a long-term expert of JICA in the Republic of Indonesia. And his co-presenter, Professor Yasuhiro Miyake-sensei, he is currently serving as a professor at the Graduate School of Law, Nagoya University, Japan. He began his professional career in 2007 as a full-time lecturer at the Faculty of Law, University of Tokyo, later advancing to this position of associate professor at the same institution. Professor Hirota Miyake-sensei, the floor is yours.
Assalamu alaikum, distinguished guests, colleagues, and friends. It's a great pleasure and privilege to be here today and have the opportunity to speak at this esteemed forum. My name is Kei Hirota, and I serve as a government attorney at the International Cooperation Department of the Research and Training Institute of Ministry of Justice of Japan. I'd like to begin by briefly introducing the activities of my department. Following that, Professor Miyake of Nagoya University, with whom we are currently collaborating, will provide an overview of how artificial intelligence, AI, is being applied in the context of legal technical cooperation. Our department the International Cooperation Department, or ICD, was established in 2001 as a department to specialize in legal technical cooperation. Legal technical cooperation means supporting mainly developing countries to improve their legal systems. That ICD has provided assistance in the areas of civil law, criminal law, and administrative law. Our cooperation consists of three main pillars. The first pillar is cooperation for drafting and amending laws and regulations. For example, in collaboration with the Japan International Cooperation Agency, or JICA, we conducted legal technical cooperation in drafting civil code in Laos, which was eventually enacted in 2018. The second pillar is cooperation for strengthening the functions of legal and judicial institutions for proper implementations of laws and regulations. Since 2015, we have cooperated with the JICA project on legal consistency for improving business environment in Indonesia. The third and final pillar is cooperation in capacity building of legal professionals like judges, prosecutors, and lawyers. In Cambodia, we have long been engaged in supporting the training of legal professionals. To date, we have provided legal technical cooperation to 16 countries, including Uzbekistan, Vietnam, Laos, Cambodia, Indonesia, Kyrgyz, and others. And this year, we are planning to begin cooperation with Ukraine in order to eradicate corruption, which has been one of the major problems in the country. Let me now briefly touch up on the role of artificial intelligence in our legal technical cooperation efforts. In some countries that we support, inconsistency between laws and regulations is one of the serious challenges. In many cases, it is difficult even to identify which laws and regulations are currently in force. We believe that this lack of legal clarity is a major factor of such inconsistency. To address these challenges, we are exploring the use of AI-based solutions, and for which purpose we are conducting joint research in partnership with Nagoya University. We are also examining, in collaboration with Nagoya University, the feasibility of applying AI to assist in the drafting of judicial sentences with partner countries. Now, I would like to invite Professor Miyake to give you further details on these initiatives. Professor Miyake, the floor is yours. Thank you.
So Miyake Sensei, the floor is yours. You can continue. Yeah. Yes.
Good afternoon, everyone. First of all, thank you very much for inviting us to the Tashkent Law Spring. My name is Yasuhiro Miyake, and I am professor at the Graduate School of Law of Nagoya University. I also serve as the representative of the SIME Consortium, a project dedicated to the development of legal education materials and the promotion of legal practice. Today, I would like to introduce our initiatives with a particular focus on digital transformation in legal education and legal technical assistance. To begin, I would like to show you a short video that introduces our work. The SIME Consortium is dedicated to delivering education that serves as a bridge between legal theory and practice, with the objective of fostering professionals equipped with effective communication skills. We have been committed to fostering academic exchange both domestically and internationally. This forum, we believe, represents a valuable opportunity to cultivate new academic partnership. Now, I would like to focus on two of our recent initiatives featured in the earlier video: the use of video materials and artificial intelligence in legal education. The video teaching materials were created out of concern that books and lectures alone might not allow students to fully visualize how the law is applied in practice. These materials have been built not only in universities, graduate schools, and various training programs, but also by a broader audience amid increasing public participation in the judicial system. Viewers have shared feedback such as gaining a clearer picture of legal procedures, understanding how the law is actually used, and discovering effective ways to study. To support learning, we have also published detailed explanatory materials in Japanese, as well as books that explain Japan's criminal procedures in English. We plan to further develop AI-based content. Today, I would like to introduce an example of legal consultation with an AI avatar acting as the client.
Good afternoon. I'm Jane Smith, an attorney. You must be Mr. Eita. Thank you for taking the time to come to our office today.
Good afternoon, Miss Smith. Yes, I'm Eita. Thank you for meeting with me. I appreciate your help. I'm facing some issues, and I hope to find a solution today.
Before we begin discussing the problem, let me explain something important. It's a duty of confidentiality that lawyers are bound by. Under the law, attorneys have a strict obligation to maintain client confidentiality. That means anything you share with me here today will not be disclosed to anyone without your explicit permission.
I understand, Miss Smith. It's good to know that what I share will remain confidential. I'm ready to discuss my situation if you are.
When it comes to resolving legal matters, understanding the facts in detail is crucial. I take my duty of confidentiality seriously, so please feel free to speak openly. Even if you think something might be unfavorable to you, or perhaps doesn't seem relevant or important, I encourage you to share it anyway. Just tell me everything as it is. No need to filter or hold back.
Thank you for that, Miss Smith. I will do my best to explain my situation clearly. So I sold 100 koi fish to a woman named Fuka. I did this to support my koi farming business. However, she never came to pick them up as per our agreement. And this led to a problem. I had planned to use the empty pond, Otome Pond, for a fishing event during the autumn festival. But since the pond wasn't empty, I couldn't carry out the event. The festival has already passed, and now I'm unsure how to deal with the situation with Fuka. I did send her a notice to cancel the contract since she didn't pick up the koi. I believe our contract is resolved, but I still have concerns about what to do next and how to handle any legal implications.
Details on the current challenges and future outlook are provided in the slides. We have high hopes for the educational benefits, but there are also several challenges. In particular, AI avatars are promising because they can help solve the problem of limited human resources and allow everyone to learn in a more active, real-time, and realistic way. Another core component of our work is legal technical assistance, which we carry out in collaboration with the ICD, as Mr. Hirota mentioned earlier. We place great importance on identifying the genuine needs of partner countries and developing content that can be realistically implemented, taking into account available human resources. One example is our work on addressing inconsistencies between laws. In some countries, only amended sections are published, making it necessary to trace legal texts over time. Our approach includes recognizing country-specific legislative terms, standardizing various data formats, and handling multiple languages. After these adjustments, the system can detect and visualize potential inconsistencies across law. Another key focus area is trial support. We are currently working on developing content that help clarify the parties' claim and organize the point of dispute. Pilot experiments in Japan have shown that this not only aids human analysis, but also significantly reduces time. Looking ahead, we aim to extend this support to the drafting of judgments. That concludes my presentation. Thank you very much for your attention.
Thank you for your presentation, Miyake-sensei. To outline, let me ask a question regarding your topic. When you mentioned about role-playing with generative AI, you pointed out visual simulation of practical legal experience. So my question is, how can students apply the outcomes of virtual experience in real life? Because they might face some difficulties in reality, as you said, real-world complexity, realistic facial expression and gestures. So just explain a little bit difference. Okay. Thank you.
That's an important point, and appreciate your observation. This content is meant to help train people on what to ask, how to ask it, and what kind of advice to give. I think there are two stages in this kind of training. And the first stage is about how to respond properly as a legal professional to what the other person says. It's a bit like talking to a chatbot, but here you need to quickly understand and organize what you hear in your head. The second stage is more advanced. It as realism. For example, the other person's facial expression, gestures, or tone of voice might suggest a different meaning than their actual words. Legal professionals need to notice and respond to those cues as well. Right now, we are working on developing content that includes these kind of non-verbal changes, so we can support this second stage of training. I would like to complete the content by the next Tashkent Law Spring. Thank you.
Thank you again, Professor. So after experience of Japan, it might be interesting for audience to know about challenges and in legal education of Central Asia. Our next speaker will give a speech on Industry 4.0 and the future of legal education in Central Asia. He is from University of Regensburg, Germany. He's currently working as a head of the Junior Research Group, Legal Transfer and Legal Development in Central Asia. He also serves as director of the Center of German Law and Comparative Legal Studies, established within the framework of the project founded by Volkswagen Foundation and DAAD. Previously, he worked as a postdoctoral researcher at the Institute for Eastern European Law in Munich. And he also served as an advisor for the Central Asian project at the German Foundation for International Legal Cooperation, IRZ. Please welcome Professor Manuchehar Kudratov. He will give his speech in Russian. Professor Kudratov, the floor is yours.
Спасибо большое, Камалович. Hurmatli форум ishtirokchilari, уважаемые дамы и господа, дорогие коллеги. Благодарю за возможность выступить сегодня. развитию прогресс в этой области является незначительным. Многие государственные органы по-прежнему работают в основном в аналоговом режиме, и страна занимает одно из последних мест в рейтинге электронного правительства, 137 место из 193 стран мира. Описанные цифровые реалии напрямую влияют на юридическое образование в Центральной Азии. И юридические факультеты региона сталкиваются с рядом структурных проблем, которые часто упоминаются в вопросах и в аналитических исследованиях. Многие юридические факультеты, особенно за пределами столиц, преподают по учебным программам, которые практически не обновлялись в течение многих лет. Перспективные темы, как юридические технологии, IT-право, защита данных и правовая экономика, часто отсутствуют в обязательной программе. Методы преподавания зачастую носят фронтальный характер, теоретический характер с ограниченным использованием цифровых инструментов или интерактивных форматов. Обучение в университетах недостаточно подготавливает специалистов, молодые судьи, модельные судьи, юридические клиники или длительные стажировки под наблюдением наставников еще не получили повсеместного распространения. В результате возникает разрыв между знаниями, полученными в университете, и навыками, которые действительно необходимы в повседневной профессиональной деятельности, например, в суде или при оказании юридических консультаций. В Центральной Азии право в основном преподается как изолированная дисциплина. Связь с экономикой, информационными технологиями, социологией или этикой, необходимой для понимания современных проблем, устанавливается редко. Совместные программы, например, магистратура по праву и технологиям, являются исключением. Таким образом, юристы получают образование в узкой специализации, не выходя за рамки своей области знания. Многие вузы сталкиваются с ограниченным бюджетом и недостаточным оборудованием. Компьютерные классы, быстрый интернет, электронные библиотеки или специализированные программное обеспечение, например, базы данных для юристов, не являются стандартом везде. Также существует сравнительно мало программ обменов, совместных исследовательских проектов или приглашенных лекторов из-за рубежа. Языковые барьеры и административные препятствия затрудняют участие в таких программах обмена. Диалог между высшим учебным заведением и рынком труда может быть также улучшен. В отличие от западных стран, здесь редко встречается структурированная обратная связь от работодателей или участия практиков в разработке учебных программ. Сотрудничество с юридическими фирмами, судами или предприятиями, например, для организации стажировок, наставничества или приглашенных лекций по актуальным делам, находится часто в начальном этапе. Инновационные формы обучения, виртуальные платформы для совместной работы над студентскими проектами или лаборатории Legal Tech, в которых студенты могут экспериментировать с современным программным обеспечением, все еще редки. Это были вызовы, которые мы обнаружили на основе опросов наших коллег и юристов. Теперь переходим к целям, какие компетенции востребованы в условиях цифровой трансформации. В ведущих юридических факультетах мира цифровые технологии становятся частью учебной программы. Все чаще предлагаются курсы по юридической аналитике, исследованию дел с помощью искусственного интеллекта. Студенты учатся, например, с помощью predictive coding, анализировать большие объемы документов или как работает автоматизация заключения договоров и электронная оценка доказательств. Некоторые вузы предлагают специализированные программы по юридическим технологиям и инновациям, чтобы целенаправленно подготовить молодых специалистов для рынка юридических технологий. Сложность современных правовых вопросов все чаще требует знаний, выходящих за рамки классического права. Соответственно, на международном уровне все больше распространения получают междисциплинарные подходы к образованию. Ведущие университеты сочетают юридические программы с экономикой, со здравоохранением, например, право в сфере здравоохранения или информатикой. Цель состоит в том, чтобы подготовить всесторонне образованных юристов, которые также в том числе понимают экономические, технические или этические отрасли проблем. Следующей компетенцией является софт-скилли и адаптивность, коммуникативные навыки, межкультурная компетентность и лидерский потенциал для успешной работы в международных командах или виртуальных рабочих средах. Также важны устойчивость и непрерывное обучение, поскольку юридическая профессия постоянно меняется, особенно под влиянием технологических изменений. Также важно экономическое и предпринимательское мышление, базовые знания в области бизнеса, управления проектами, комплайенса, чтобы иметь возможность оказывать юридическую поддержку клиентам в цифровых бизнес-моделях или стартапах. От будущих юристов также ожидается знаний в области этики и социальных компетенций, осмысление этических последствий использования технологий, например, предвзятость алгоритмов и способность работать на социальных значимых стиках, как защита данных или права человека в интернете. Кроме того, важно глобальное понимание права, способность мыслить за пределами национальных правовых систем, например, в случаях трансграничной киберпреступности или международного арбитража. Для достижения данных целей нужны реформы на 3 уровнях. Это в учебных планах, включение дисциплин legal tech и право экономики, управление проектами, а также модули, которые ориентированы на практику, кейсы, симуляции, проектная работа, также юридическое письмо, поиск правовой информации и управление проектами. На уровне преподавателей нужны курсы повышения в области цифровых технологий и методик преподавания, обмен с техническими университетами и международными программами, в том числе Erasmus+, или DAAD. На институциональном уровне это создание цифровых лабораторий, юридических хабов при университетах, региональная кооперация, например, Централизация альянс юридических школ, или же программы как «Юрист 2030», формирование новой модели выпускника. На этом у меня все. Спасибо за ваше внимание.
Спасибо, профессор Кудратов, за содержательную презентацию. Я понимаю, что вы сделали мета-анализ по Центральной Азии, но то, что вы сказали, уже имеется в Ташкентском государственном юридическом университете про Tashkent Law Laboratory и другие вещи, например, междисциплинарные науки тоже изучаются, например, факультеты бизнес-права и других факультетов. Но мой вопрос в другом. Вот вы в своем докладе в последнем предложении сказали, то есть предлагали новую модель выпускника. Вот интересно, что такое как понимать новую модель выпускника и какими компетенциями должен владеть этот выпускник новой модели?
У меня слышно, да? У меня две.
Да, можете говорить.
Ответа. Данные, которые мы собрали, это не только вузы в столице. Столичные вузы обычно имеют очень хорошую инфраструктуру. Обычно в регионах все это довольно скажем, я бы не сказал плачевном уровне, на низком уровне. Касательно второго вопроса. У меня был недавно разговор с одним из разработчиков искусственного интеллекта под названием Cloud. Я не знаю, кто-то знает или нет. Это похож на ChatGPT. И он мне рассказал очень интересное описание. Он сказал, искусственный интеллект на данный момент, 2 года тому назад был искусственный интеллект на уровне студента. На данный момент искусственный интеллект находится на уровне докторанта. И в течение будущих 3 до 5 лет искусственный интеллект будет на уровне профессора. Теперь к будущим юристам. Для меня будущий юрист или юрист, который мы должны подготовить к 2030 году, он должен понимать, как работает искусственный интеллект, он должен это осознать, и он должен в случае нужды регулировать. А без понимания всего этого, я думаю, мы не сможем регулировать искусственный интеллект.
Спасибо. Спасибо большое еще раз. Our last speaker for this panel is Professor Raimundus Kalesnikas. He's a professor of Faculty of Law, Turiba University, Latvia. He has over 20 years of professional experience in legal, scientific, project management, and expert activities in national and international levels. He is a member of Senate at the Institute of Law and Technology at KSU University. At the same time, he is a certified auditor and consultant on anti-bribery management systems, a member of the Bar Association, and practicing attorney at Temedi Law Firm. He will give a speech on the transformation of legal education from 1.0 to towards 5.0. Professor Raimundus, the floor is yours.
Thank you. Ladies and gentlemen, esteemed colleagues and distinguished guests, it is a great honor for me to be part of this prestigious event, which are dedicated to the digital technologies transformation to the legal education. And I sincerely thank for the organizers of that event for the invitation and given the opportunity to speak in that global event. Today I'm delighted to present my talk on the topic which I related with the transformation of the legal education using some interesting acronyms. We see the numbers 1.0, 5.0. That figures or numbers is used from the industry. If you see the evolution of the industry, and time by time that industry incorporated these figures not only in the education but in the government sector, in the even in our life too. And according to that, very important to understand what is the advanced knowledge, skills, and competences is required for the training the legal professionals in the future. Because today we had many discussions and many good presentations, and my presentations more or less also are related with that issue. First of all, I would like to say, because my experience in this legal education area is around 30 years. Starting from as a young researcher, and today I'm working as a Bologna expert also, what are doing the accreditation and assessment, how the universities and higher education institutions are comply with the new standards for the legal professions. So, can we speak about ecosystem of the legal education? Yes. Because ecosystem has a big elements. And in 21st century, we need to speak about, I love to use the business terminology, quality, uncertainty, complexity, and ambition, because this VUCA terminology is used for the forestry science. Today is the new vision in the research, technology, development, and education. And these orientations, you know, knowledge and skills is not stand in the past. It's the ever fast production of the knowledge and skills is looking for. And who is responsible for that? Higher education institutions and university. And they need to combine that knowledge. And I see today, if we speak about elements of the ecosystem of the legal education, where to focus. The center figure today is the learner. And the learner is affected by various factors. And that system, we should, for the managers, for the strategists, and for the state developers of the education in the future, they should focus on the institutional development. What kind of a university? I see that in the future we speak about digital university, not will be the stand with traditional universities. Second, curriculum and pedagogy. Today we have nice presentations in the beginning about pedagogy. It's the same that you presented also. Stakeholders, who are beneficiaries of legal educations? Of course, we have legal professions which are very important. We speak about prosecutors, judges, attorneys of law, notarians, and so on. But legal compliance officer, if I open the job proposals or recruitment, we see that legal professionals need who are very well knows how to manage the cyber risk, security risk, how to ensure the protection of data, how to use this technological in the money laundering, to prevent the money laundering, and so on and so on. It's new knowledge and new skills. And that, what we speak about technology and innovation, we seek that using a new acronyms like E, because we have e-court, e-case, e-justice, e-learning, and so on and so on. But one very important, how we assess the quality, what we teach. Quality is a new challenge. We speak about this blended learning, about distance learning, but quality stands also very important, because legal professionals, the people of these beneficiaries of clients must trust what we are produced, even using this technological progress. Here is practice, and you see the practice is very interesting. If we speak about evolution of the legal education, every country could assess themselves where we stand. Usually now we stand on the 0.4. What we are speaking about digitalization of higher educations and especially legal education. Here you see the practice of our country, because I represent Lithuania, how we transform that. That process from 2.0 until 4.0, because we are now on innovation in the research and education, we get 25 years to achieve. But to go to this personalization of higher educations, what I love to see, what will be the learner and the central figure, it will be very fast. We need to ready be now, because it's within 5 years we get the speak about 5.0 point. But I get a lot of information during in that event. And here, after 5 years, we now get the conference where I speak only about legal education using 5.0 point. I mean, with educations would developing thinking learners and future-oriented law graduates with the global mindset. And it's future of our knowledge and skills pool for the young legal professionals. And here I'm not take a lot of information, but one interesting survey done by European Union. That survey was done last year about European skills and job survey. Is what is focusing on all job profession and skills. And I here take only legal professions with comparison with other professions. And you see, in the future, legal professions need to be more beneficiaries, I mean more attractive in the job market. And the most legal professions, by the age, our target group, if you would like to learn or to train legal professions is from 25 up to 49 years. It's the main target group when we speak about legal professions. And the demand is very high. We could find that up to 20% in the European Union will be demand for the legal profession. What the skills requested for the legal professions? There are four areas. As you see, there are innovative skills, interpersonal skills, and literacy skills. And most of them are requested design on improving the legal service using new technologies, or using, as I call this, legal tech instruments or tools. And here is very important. Most of the survey, the answers was that the gap or lack is the digital skills and knowledges for the legal professionals, because we have the upskilling. I did not find the presentations about upskilling, because it's very important, because we have a lot of legal professions who are currently, they couldn't very fast develop, and this upskilling also is the challenge for universities, where are also many European universities are doing this upskilling trainings and for the legal professions, inviting prosecutors, judges, attorneys of law, notarius, bailiffs officers, and so on. And I would like to say that we have some. What is my conclusion? In this conclusion, we need to speak about what is the profile of the legal professional today. We need to get the clear standard for the legal professions, including what kind of knowledge, skills, and competences they need to have. Today in the morning, I did the presentations about that. In the Youth Legal Forum, I presented very skills mapping, what is for the youth, future lawyers. And this body of knowledge and skills is very important thing that, as you see, is not only in the interpersonals. There are some other knowledge, what I call digital knowledges, is very, very important in that context. And this, we not to forget that lifelong learning for the legal professionals, for upskilling, is also a target which will be fixed in some strategic documents in the future. And my recommendation is there are 3 points. That if you would like to be effective, legal professionals must have continuously improve their professional skills in the strategic thinking, technological know-how, as we speak about artificial intelligence in the legal industry, and managing regulatory compliance. Because a lot of compliance, we need to know that legal officers would request some special businesses. And that we do not forget is very important. The third point is that we need to adapt our regulatory and ethical shifts in the legal practices. Even that technological and artificial intelligence not should limit the human being. I mean, limit human rights, and these ethical values are very important, how to ethically use these technologies and artificial intelligence. Thank you. If you have a question.
Thank you, Professor, for your speech. I have just one question. When you described elements of the ecosystem of legal education, you rose the idea of thinking learners. So as a central element of this ecosystem, and as you know, there are two main approaches regarding learners. The first one, student as a producer. The second one, student as a consumer. So my question is, do you see some risks that by excessive use of digital devices, learners can become consumers but not producers?
Yes, thank you for the question, dear moderator. Yeah, it's very actual questions. In the future, if we turn to the technological progress and to 5.0 industry on the legal education, I see that the role of the teachers, because students will become more and more independent in that context. And students come to universities to get their knowledge and skills. And the teacher should be like a mentor. We do not have a traditional teacher, but he provides, okay, please look here, please, I provide for you with material. No, because the students get access for everything. And that platform, e-learning platform or e-tools, it should create it. And teachers' role in the future will be like mentor, and the role will be mentorship. And students will be like our, not customer, but like our partners in that context. Thank you.
Thank you again, Professor. Before we go on to Q&A session, I want to see whether our panelists have any comments on each other's remarks. Do our panelists have or not? Okay, if there is no remarks, so I would like to provide the floor to the audience. So if anybody has any question, so please feel free to do so. Just a minute.
Yeah, good part of the day. And my question is directly addressed to Professor Thompson. So I'm very much grateful for your speech. And my question is about threshold requirements for professors to teach law. Because it came as a surprise to me when I was studying at Tashkent State University of Law. Most of our professors were quite young. And yet the quality of their teaching was very high. And while I was studying at the Queen Mary University, I picked up on the fact that most of my professors were above 40. And I guess that it's because of the threshold requirements that were set out by our university, that you have to done your PhD, get some sort of experience, legal experience, and etc. And what's in your vision the key assets that one should assume in order to ensure that his teaching is delivered with very high quality? And my second question is addressed to our guest from Azerbaijan, to Elchin Abzar Khalafov. Если хотите, я могу задать этот вопрос на русском языке. Благодаря мудрой политике глав наших государств, Узбекистан и Азербайджан уже стали союзными государствами. И, соответственно, получается, наши правовые системы друг на друга очень сильно похожи. Но при этом, получается, если, скажем, юрист из Узбекистана хочет практиковать, например, скажем, адвокатскую деятельность в Республике Азербайджан, реализовать он это, к большому сожалению, не сможет. Хотя, несмотря на то, что в наших правовых системах очень много схожих черт. И фактически наши правовые системы, благодаря культурным, языковым и иным особенностям, являются друг другу очень идентичными. Не думаете ли вы, что пришло время как-то унифицировать требования к адвокатской деятельности Республики Азербайджан, Республики Узбекистан, может быть, в перспективе и в других странах Центральной Азии, дабы дать возможность юристам стран из союзных республик практиковать право в обоих государствах? Спасибо.
So we'll begin from the Professor Thompson.
Yeah, thank you very much. So your question around teaching quality and how we can ensure that, or what we might look for, I would go back to one of the slides I shared with you, which was by Lee Shulman and his wife Judith Shulman, in which they talked about an accomplished teacher. Now they're talking about a school teacher, but I say that applies to anyone involved in education. And there's an element, the things at the beginning which are about vision and about motivation and about ability, those things are not necessarily age-related. But the ones I think are key as you move through a teaching career are the final two, which is about your ability to reflect upon experience and to learn from that experience and the ability to learn from others. Now, if you have those two commitments throughout your teaching career, then you can maintain that requirement to keep building upskilling, which was shared by my other speakers. So I would say that those last two, the importance of being reflective and of working as part of a community, would be key for me in working with educators who are new, but even someone who's been teaching as long as I have, I would want those two aspects of their practice.
Спасибо. Если вы позволите, хотел бы еще прокомментировать вопрос, который вы задали профессору Томпсону, да, по поводу возраста преподавания. У нас есть такая пословица, наверное, не знаю, как будет звучать на узбекском языке. Ағыл яштады, баштады. Ну, бәзен, иногда, ағылы баша гетрен де яшты. Это тоже надо учитывать. Поэтому, что касается вопроса, который вы задали мне, я с вами совершенно согласен, что в рамках партнерских отношений, братских отношений между Узбекистаном и Азербайджаном идет постоянная интеграция. И более того, эта интеграция идет в рамках организации тюркских стран, которая будет приводить к унификации нашего законодательства, прежде всего регулирующей торговую деятельность. И не исключено, что это коснется также вопросов образования и вопросов признания взаимных дипломов, и в последующем вопросов, связанных с профессиональной деятельностью, деятельностью адвокатов. В настоящее время законодательство не позволяет это делать, но я думаю, что в ближайшее время, в ближайшие годы этот вопрос может быть поставлен на повестке дня. Болонская система сегодня нам позволяет обмениваться студентами, связанными с выбором кредитов. Я из Узбекистана пока в Бакинском государственном университете не встречал студентов, но студенты есть из Казахстана, есть из Турции, так что эта система сегодня позволяет нам выбирать кредиты. То есть студент сегодня Ташкентского университета в рамках договора между университетами может выбрать кредиты и один семестр проучиться в Баку. Так? Безусловно, это тоже будет способствовать интеграции в этих процессах. Спасибо большое.
I think most of you have a question, but you can continue your discussion on the cup of coffee. They talk over with a cup of coffee, and it's time for the coffee break. So I would like once again thanks to our brilliant panelists for their insightful presentation. And the next part of our discussion will be at 5 o'clock. So see you at 5 o'clock here. Thank you. Thank you.
Hal qo'yamiz buni. Buni nima qiladi? O'tiraveradi.
Sal tortib turing.
Сейчас они это на минимальную скорость. Перестановка делается.
А?
Перестановка делается.
Да, это просто stol.
Mashina.
Yo'q, endi bu ikkitasini o'rtasida bo'lsa bu buni bu yoqqa olamizda.
Ikkitaga bitta bo'lsa, bunga bu bo'lsa, taklishni qo'yadi.
Yaqinroq qo'yamiz-da, yo'q. Yoqdan qarang, yana qasddan. Mikrofon yo'q, yetsa hamda.
Yetadi. Mana qo'yamiz, shoshmang. Mana qo'yib qo'yasiz.
Hozir nechta odam ekan ichida? 35. Mana borishcha bo'lib qoldi. Milliy deb tushunmadim.
this one. Okay, so we are now in the digital age. So now, when I go to some conferences, so they are actually doing e-business card. So some people will actually show me in the conference and so say that, okay, Howard, so if you want to get hold of my detail, you can scan this QR code. I think so we should actually do something like this.
I click it here. Just please pass it after your presentation. Dear ladies and gentlemen, we are going to begin our next part of the session. So please have your seats, please. So just So before we begin the second part of our session, I would like to conclude the first part of our session and with the ecosystem of legal education as a main element with the learners as a central place in the legal education, and we discussed the general issues about legal competences, how we make a balance between general legal knowledge and using AI in the first section. And we'll continue with the specific details in the second part, and we'll continue with the topic, how to make balance between the basic legal knowledge and using the AI and other innovative tools. So in this regard, I want to start with the first speaker, Professor Mark Bugenberg. He's a director of the European Institute at Saarland University, Germany. He holds the John Monette Chair Professorship in European Constitutional Framework for International Dispute Resolution and Rule of Law. He has been included in the European Union list of potential arbitrators for trade and investment disputes. He also a member of the Scientific Advisory Board of the International Investment Law Center in Cologne. He will give a speech on the importance of substantive legal knowledge in the leveraging AI in law. Professor Bugenberg, the floor is yours.
Thank you very much. Okay, so the presentation is on. You see again my topic. And well, as many others obviously did, I prompted this and did take a look what a ChatGPT would give me. Colleagues yesterday, also today, said, well, they did not do this. It's all human, just personally generated speech. Well, I tried my topic, and I must say, well, I kind of threw the outcome away, because what ChatGPT gave me was something I also heard during the past 2 days. Nevertheless, past 2 days I've had a steep learning curve, and so I rearranged also the first outcome of the ChatGPT. I rearranged and until I reached kind of a halfway satisfying result where I thought, well, that might get into the right direction. It did cost me probably some 2 to 3 hours. I had on my mind what I wanted to talk about, and just taking the notes after a few years of experience, I would say that would have taken me probably 1 hour, 2 hours. For a speech, you never really have to do that much research if you work on your own topics. So I would say I did not save any money, and I did not save any time. Time is money, but I wasted time and money by using chat in this way. So the outcome was not that satisfying to start with, not when you give your speech, give your presentation at an occasion where all co-speakers, probably 60, 70 people, speak about similar topics. So it'd be very, very repetitive if we all used ChatGPT and nothing new would come up. Well, so this was kind of a starting point, a depressing starting point actually, when I wanted to prepare for this conference. I must also admit, I worked with ChatGPT the past couple of months already, because I've 3 boys, well, they're just finishing high school, just finished high school, and I saw how extreme they use it. And I thought, well, I have to get, familiar with this new tool. For you, most of those in here in this room, it's not that new anymore, but for the professors, they keep some distance. At least where I come from, my colleagues are very, very conservative. And they just start to learn. I've started to learn to use it a little bit a couple of months ago, probably a year ago, so I've been playing around with it. But most of my colleagues have not, at least not yet in Germany. But probably the German professors are more conservative than elsewhere. And we heard earlier on that here in Tashkent, lecturers are quite young, whereas in, Western European countries, to become a lecturer, to become a professor, it takes a long time. So probably it's also the age that comes with it. Well, the question I want to address, and the question that has also already been answered here and there, is what kind of human experts do we need in the legal profession? What are our tasks in the future? Does it mean we have to be even better lawyers? Or can we get lazy, take a break, because AI is going to help us? I'm going to come up with 1 or 2 examples, just very recent examples, where I had kind of a wake-up call for myself. I will demonstrate AI is powerful, but only with very, very sound legal foundations. Here I still said arbitration I will take as case study, but I sent my slides some 8 or 9 days ago. I skipped this, so this is also the problem. Everything is moving on so fast, and you kind of see new and probably better examples, so you just skip this and that. So I try to demonstrate how powerful, but also how dangerous AI is. Well, this is a point ChatGPT did not come up with. Ricardo question to begin with. Some of you might know who David Ricardo was, one of the most famous economists of the 18th and 19th century. He came up with the example of comparative advantages. And I always use David Ricardo when I explain trade theory. And I try to explain trade theory with a personal example. Why would I hire a human assistant? I also here and there provide experts' opinions. They are pretty good paid. And nevertheless, when I draft this expert opinion, I would usually hire an assistant. Why that? I'm I think, in most legal spheres, a little bit better than my assistant. I am a lot faster when it comes down to research. Still, I hire an assistant to actually gain an economic advantage. Even though I do everything a little bit better, in my assumption, I still hire this assistant. The question now is, it saves money to hire an assistant to delegate certain things. Do I still need this human assistant in the future? Or will my assistant in the future be AI? Will it be ChatGPT, something similar? Well, we'll return to this. I want to skip a couple of slides and directly come to the conclusion connected with one or two examples. I would argue Ricardo still applies, but it only applies with highly educated assistants. So I'm speaking from my perspective as a professor preparing, for example, an expert opinion. It would be the same for a partner in a big law firm. Does he still need actually an associate or paralegal, or could he do everything by himself? And I would always argue, yes, we still need this kind of different levels. Different levels, why? Because AI still is dangerous and will remain dangerous. And to control AI is, again, as I also tried to explain in the very beginning when I prepared my speech here, my presentation here, it is time intensive to control AI. So from my perspective, lawyers must be even better than in the past. I'm going to give you an example. I'm working quite a lot on what you call economic sanctions, so restrictive measures, embargoes, and so on. Yesterday, I prompted ChatGPT with a question: who actually has the competence to adopt economic sanctions? So that was quite easy. Then the questions I gave to ChatGPT became a little more complicated. And I came up with what I believe is a false assumption. So I prompted ChatGPT with a false assumption. Then ChatGPT actually started trying to give me reasons why my false argumentation makes sense, to actually come up with arguments to help me with my false assumptions. Then I asked ChatGPT, well, please help me with some jurisprudence, Supreme Court jurisprudence. Come up with a big case. Well, Chat helped me, came up with a European Court of Justice, or the highest court in the European Union case. That case existed. The case numbers existed. The parties existed. And the topic was quite similar. This judgment actually dealt with economic sanctions. Then I said, I prompted ChatGPT, well, please give me the exact number, the exact paragraph, give me the wording. ChatGPT gave me the wording. Then I compared the exact wording with the online resources of the European Court of Justice. And what ChatGPT did was, ChatGPT worked on an existing judgment, but changed the wording of actually the reasoning of the Court of Justice. So very, very dangerous. Coming up with the right case in the right area, but you have to really read very carefully, otherwise you would not detect that it is kind of changing already words. That is, from my perspective, one of the most dangerous cases when you just change a nuance. To detect this, from my perspective again, you need very highly educated human beings. So again, just an example, lawyers must be even better than the past. We must combine what I would call an AI Methodenlehre, so learning the method how to deal with AI, together with, well, sound legal education. The future, of course, it is hybrid, it's not robotic, but we need to combine two methods in the future, and we cannot rely on it. But to be able to control this, again, high standards, high legal standards, and this means David Ricardo's approach with comparative advantages still applies today, but it's more complicated. It's kind of a three-level, theorem now. And, the lowest level should be always AI. AI needs to be controlled, and the one who controls it actually gives the partner in a law firm the comparative advantage. I'm going to close with this. Thank you very much for your attention.
Thank you, Professor, for your speech. Just outline. Let me ask one question. You come to conclusion that substantive legal knowledge still matters and AI methodology must be combined with basic legal training. So my question is that, is there any best practices regarding this kind of combination in legal education, for example, in Germany or somewhere in the world?
Well, as I said in the beginning, we're just at the universities discovering there's something we call AI. I would say at the universities we are behind. So we have to implement these tools that at the universities, right now, at least in Germany, we're not doing. What I take back from these 2 days also is we have to adapt our programs. The problem is that a lot of colleagues are just very conservative and believe in what has been taught in the past 50 years and the way it was taught in the past 50 years. Must not change, should not change, does not need to change. And so I think right now it is also, first of all, the discussion about being ready for innovation. Probably we are not there yet. Some of the colleagues are, but the majority, I would argue, is not yet. And I was quite critical until a few months ago, I must admit. I've changed my mind, my mindset. I'm more open now, but probably it takes some personal experience as well and openness.
Thank you again, Professor. Now I turn to our next speaker, Professor Konstantin Xalqaro. He's a professor of human rights at the University of Liverpool, the United Kingdom. And at the same time, he serves as the Deputy Dean for the International Engagement at the School of Law and Social Justice. He joined the University of Liverpool in 2015. Prior to that, he held academic positions at the University of Surrey, United Kingdom, University of Dublin, Ireland, and Gomel State University, Belarus. Konstantin is a co-founder and co-editor-in-chief of the journal European Convention on Human Rights Law Review. He also heads the International Law and Human Rights section. He will give a speech on teaching law in Liverpool in 2025, Challenges of Digital Age. Professor Konstantin, the floor is yours.
Thank you very much. I can see my presentation up. It's nice to be here, and obviously this is the very last session of the forum, so we can be a little bit relaxed on everything. So I will give you a little bit of a relaxed presentation. And first of all, I wanted to echo what the previous speaker said. And we know that AI hallucinates. Yeah, they come up with things that don't exist. And there are plenty of examples, and my learned colleague just gave a fantastic example. I also have my own example. A couple of years ago, I asked ChatGPT about who is Konstantin Xalqaro. Who am I? Right? And ChatGPT was super nice, super good. ChatGPT told me, Konstantin Xalqaro is a world-famous professor, leading authority in the European Convention on Human Rights, fantastic academic. I was very pleased. And then ChatGPT started listing what it thought were my publications. And these publications exist. The only problem is that I never wrote any of those publications. I never wrote any of those books. So I agree with you, this is a very, very dangerous thing, and you can really be in trouble if you rely 100% on ChatGPT. Also, if you're for students, the first thing I check when I mark my papers and courseworks, whether ChatGPT was used, I check the footnotes. And you can identify ChatGPT from footnotes because it likes to create footnotes that don't exist or link them to the text that is not connected to what they're saying. So I hope none of you would ever use ChatGPT for your coursework, but if you do, check your footnotes. Now, right, so now basically Professor Khodjaev was so strict with us that he asked us to submit our presentations 3 weeks ago, which in my experience never happens, you know, and this is good. You get very well prepared and stuff. The drawback of this that I cannot remember what in my presentation, so I will be right now as surprised as you are on what's there. The title of my little presentation is Teaching Law in Liverpool in 2025. It is a bit ambitious of me to talk about teaching law in Liverpool because there are 4 universities in Liverpool. All of them have law schools, and I have no idea how they teach law in 3 of them. So I will be speaking a little bit only about my own university. And final point that I wanted to make before we get started is that I'm feeling a little bit about imposter. With Professor Khodjaev told me that he wants me to present something about AI and legal education. I thought, well, I'm involved in legal education, of course, but this is not my core area, right? And so what I try to do what is well described in an old joke. That goes that like there was a student in biology, right? Biology student, right? And he only learned one part of biology that was connected, like describing worms. You know, he only knew everything about worms, right? And when he goes to the exam, he gets a question, and the question is about elephants. And elephants have nothing to do with worms. So he starts and saying, okay, the trunks of the elephant looks like worm. So let's talk about worms. So that's exactly how I'm going to link my the discussion about AI to the point that I'm making through my teaching that I do in Liverpool. So there is, my area is the European Convention on Human Rights, which establishes the European Court of Human Rights, which is based in Strasbourg in France. I was going to ask you a couple of questions, but I'm afraid I don't have time about that. Let's leave it at that point. So what digital technologies and AI have already changed in our understanding of reality? First, the AI and digital technologies change the content of the modules that we already study. And the old-fashioned, so law of the European Convention on Human Rights is a very old-fashioned legal discipline. And this is a traditional module, and, but even this module undergoes very significant transformation. So here's an example of, and I will give you a little bit of a substantive law now, which probably going to be fun or not, you'll tell me, how we teach a particular part of this module. So one part of my module deals with privacy rights. So right not to be subjected to various forms of surveillance, right? And traditionally, surveillance was limited to phone tapping, to old-fashioned, like, you know, some James Bond going after you kind of stuff. But now the situation completely changes with introduction of AI technology, and this is quite dangerous. So as I always say that there is the judgment of the European Court of Human Rights for any eventuality of your life, I wanted to give you an example of the case of the European Court of Human Rights. In the ECHR, individuals can bring the case against their government, and this is one of these cases. And this case is called Glukhin versus Russia. So what happened in this case? The applicant in this case traveled in Moscow underground with a banner that said, "I am facing up to 5 years for peaceful protest." So he was effectively protesting. And then photos of him were uploaded to Telegram Messenger in some groups, and this became known to the government. So 7 days later, he was arrested, but also he was arrested in the underground, where there are many people. And the issue, he was fined for that. This is interference with freedom of expression and association potential, and he complained to the European Court of Human Rights under Article 8, which protects right to privacy that I already mentioned, and Article 10, which protects freedom of expression. Because, why? Because he argued, and this is the crust of the problem, he argued that the government used face recognition technology first to identify him on this photo that was uploaded to Telegram, and second, when he was traveling in the tube, in the metro, the government used face recognition, live face recognition technology to identify who he is and where he was. And he argued that this is an infringement into his privacy. Now, there are different types of face recognition technology, and although government of Russia didn't admit that they used face recognition technology, it was clear that it was used in this case, because they couldn't know that he is in that particular moment, in that particular station in Moscow underground, without using that. So there are two types of face recognition technology. One is ex-post face recognition technology, which was used to find out who is on this picture uploaded to Telegram. And the other one is live face recognition technology, is when you are going through the video camera on the metro, and you can be recognized by the government that you are specifically here at that time. Now, and he argued that both of these instances were a violation of his rights under Article 8 of the Convention. Briefly, what the court decides, I'm not going to read it all. The court found that this use of face recognition technology was a violation of Article 8 of the European Convention on Human Rights, and well, ruled in favor of the applicant in this case. I just don't have time to go into more details of the case. If you're interested, ask me at the end. Fascinating case. Now, but what I'm trying to say, that even the content of very traditional modules, like my own module of law of the European Convention on Human Rights, is changing because the European Court of Human Rights has to deal with cases that are starting or which are, you know, like at the source have this new technology. So as much as you're a conservative professor in a conservative state, you cannot ignore these kind of developments, and like law of a particular area would change, it would reflect that changes. But then we also can have new modules and new areas, like yesterday the Minister of Justice of Azerbaijan, he was talking a lot about like changes to curriculum. We're already doing that, maybe not as radical as he was thinking about, but we're already doing that. So last year we have a couple of modules like that, but we introduced an LLM module on digital justice and emerging technology, which includes areas such as like right to fair trial and digital courtroom. And this is incredibly important, especially after COVID, right? After COVID, during COVID pandemic, most of the trials, excuse me, most of the trials went online, and we were not prepared, but there are massive limitations to that move. And I remember a couple of months ago, I was in Kazakhstan at the Fair Trial Forum, and the Kazakhstani authorities very proudly and very nicely reported that like a massive number of trials are fully done online in Kazakhstan. And they presented it as a very good thing. And I think it might be a very good thing, but it also can be a very concerning thing when you don't see, when the judge cannot see the, like the defendant, to see like what his reactions are to a particular question. So that is one of the issues that we deal with within this module. We talk about digital justice and mass surveillance, massive thing everywhere in the world, everywhere. We talk about dark web investigations and privacy. We look at recovery of process of crime in digital crime. So like plenty of aspects, and you see this is a very multidisciplinary module that cannot be seen from one perspective. It's criminal law, it's human rights, it's I don't know, migration in some point, in transnational crimes, whatnot. Now, does this mean that my time is almost up? The darkening of the room. That's very dramatic, like in the theater. Like we went to the opera yesterday, so I will sing my. No, please, I'm not gonna. I know it tells me that time is up. Here we go. 2 minutes. But generally, there are plenty of areas where digital technologies, AI and stuff are encroaching into our life, and we cannot stop it as much as we would want. We cannot. Legal research, extremely important area. Digital technologies, AI is already doing things. Especially those of us, and I do quite a bit of quantitative research. ChatGPT helps a lot in organizing. I'm awful, I cannot use Microsoft Excel, it's terrible. You just tell ChatGPT to create a nice table for you, it does it easily. But this is also very problematic. What is creating a ChatGPT table is all right. There is no plagiarism involved. But what if you ask more? So where is the borderline here? Digital technologies and assessment, Simon was talking about this a little bit earlier. Can we use digital ChatGPT in assessment? Once I tried ChatGPT to draft a hypothetical case for my exam, it did an absolutely awful job like a terrible job. Like it didn't help me at all. We can do AI-based simulations where you, as Simon said, when you expect students to use AI, because they will be using AI in practice. So maybe it's a good idea to teach them how to use it properly. And legal practice and legal academia, digital technologies, we spent like two days discussing them. So thank you very much for your kind attention. I hope.
Thank you, Professor, for your speech, and I'm sorry for the pushing up you.
No.
It's a presentation, but
I'm very grateful. If I'm not pushed up, I would keep talking and I will miss my flight on Monday.
We just meet the line, and you can ask the ChatGPT or AI. So I'm not a strict person, and you can confine this.
I will.
Okay, just as a conclusion of your presentation. I would like to ask about digital technologies. You said that digital technologies change the values of democratic society. So if digital technologies change the democratic society governed by rule of law, how it will influence the priorities of legal education?
That's an excellent question, and you need a bit of a crystal globe to see how that legal education will react to the challenges of artificial intelligence. I think we are very slow in doing that. For example, in my university, in my law school, the position is that students cannot use AI support in their coursework or anything, and of course they do, but how do we know? So basically, I think the principles that we are using at the moment are a little bit wrong. We need to embrace the reality and be realistic about what we demand and how we deal with this reality. Otherwise, we will be redundant and students will keep using tools, but we will be just like in the dark and we will not, catch up with this development. Thank you.
Okay. Thank you again for your speech, Professor. Thank you again for your speech. And now I would like to introduce our next speaker, Professor Hans-Joachim Schramm. He's academic director and professor of the business law at Wismar University of Applied Science in Germany. He's a recognized expert in business law and legal reforms in economies of the digital era. His extensive experience as an advisor on legal reforms in Central Asia and Eastern Europe and has participated in drafting model legislation for CIS countries. He will give his speech in Russian or in English. Okay, in Russian on legal education in digital age, tradition and challenges. Professor, the floor is yours.
Уважаемые гости, уважаемые студенты, здесь я чувствую немножко некомфортным, потому что я устарел. Слушая такие темы, я вижу, у меня есть представление, может быть, вы знаете, это куклы Muppet Show, там есть старые Вальдорф и Стедлер, которые старые лица, которые всегда ругают. Все-таки я хотел с вами разделить некоторые идеи, которые направление которое состоит в том, что вчера мы слышали, и сегодня мы слышали, что есть огромное обещание искусственного интеллекта. Все будет лучше, обучать легче, право будет лучше. И я хочу разделить с вами, что надо, скажем, опасности. Опасно. Почему? Почему немецкий профессор может здесь перед вами стоять и сказать обучение вас? Потому что я из Висмара, и в Висмаре мы имеем двойное дипломное обучение на мастерском уровне. К нам приходят студенты не из Узбекистана, но со средних стран. И извините, такие студенты пока не были бы в состоянии работать в адвокатском конторе. И боюсь, что только просто применение техники искусственного интеллекта или ChatGPT это не изменяет. Что-то отсутствует. Об этом я хотел с вами поговорить. Вот этот Все это уже сказано, что надо добавить к обучению. Это без сомнений. Это без сомнения, все это будет. Все это. Но разрешите все-таки мне разделить, когда я вижу эти аватары. Пожалуйста, спрашивайте. Я могу спрашивать, что я вспомню с моего времени обучения. Это были слайды или личности? Я вспомню личности. Это не аватар, но тогда не было, но бумага тогда была. И думаю, что на базе этого эта задача профессоров повышается. Задача профессоров – это у вас загорится огонь любви, любовь к праву. Извините, ваше слово, это студент, это слово латинского студера, это значит стараться. Все эти техники, может быть, они вам поможет, но все-таки стараться – это фундамент. Если эти слайды вам интересны, возможно, разделить после этого. Я хотел с вами такие идеи. Если мы уже больше опытные юристы, которые должны привыкнуть к новой технике. Это всегда так было. Ваше поколение, по-моему, другой подход. Вы уже привыкли к этим техникам. И моложе еще лучше. Они растут, пользуясь этой техникой. Или только потом узнают право. По-моему, это не так просто. Потому что они спрашивают что-то от ChatGPT, и они доверяют. Это много знает. И в этом это один из самых лучших пунктов, о котором уже профессор уже говорил. Вы должны быть лучше, чем ChatGPT. Больше знать. Выхода нету. По-моему, есть разделение юристов. Извините, нестремительные юристы, которые все пользуют, которые скажут IT, и такие юристы, которые в состоянии проверять результаты. Это еще в этом направлении будет. Значит, вы должны понимать фундамент права. Какой фундамент? И об этом я хотел коротко останавливаться, потому что это мой ключевой пункт, который, сколько я знаю, здесь немножко отсутствует. Я был в книжном магазине университета. Я там нашел интересную книжку, это юридическая техника. Об этом я говорю. И у нас это называется законный метод. Законный метод по-английски это legal reasoning. Legal reasoning, юридическая техника или юридическая метода. Я хочу, что вы чувствуете, в чем это смысл. В чем конечный пункт вашего образования и нашего образования. Наше обучение направлено на то, что юрист в состоянии стать судьей. Что должен сделать судья? Судья должен принимать решение, которое быть законным и обоснованным. По-моему, это фундамент, который и действует у вас. Ваша задача в конце обучения – это должно быть состояние писать или принимать решение на базе закона, который есть обоснованным. И вопрос методика отвечает на того, что это обоснованным. Как обосновывать юридические решения? Это субъективный фактор, конечно, есть. С другой стороны, и в Англии, и в Америке, и в Германии, и во Франции есть определенные юридические методы, на базе которого возможно оценивать, если решение если решение обосновано. Это не значит, что я должен согласиться с этим. Но в всяком случае должно быть по методику хорошо обоснованном. И, по-моему, это много даст. Это много даст уже на вашем уровне, как проверять студенческие работы. Субъективный фактор. Хорошо писали, нет. Дополнительно должно быть какой-то объективный фактор. И эта методика, по-моему, даст возможность проверять юридические решения по объективным причинам. Какие методы? Здесь, по-моему, вы это знаете, есть англосаксонский систем, common law и континентальный европейский систем гражданского права, да, civil law system. У них есть разные подходы. У них есть разные подходы. У нас на континентальном системе это больше система дедукция. Есть общее правило, принципа, из этого надо найти решение к определенным казусам. Англичанин пользует другой подход. У них есть прецедентного права. Значит, у них есть какой-то казус, который был решен, и есть другой казус, и сейчас они должны сравнивать. Это похоже, совпадает? Они, индукция из вниз наверх должна найти общие принципы. Что вы должны уметь? Вы должны уметь обе техники. Обе техники. Я сторонний, с одной стороны, должны быть лекции, которые вам дают общий взгляд о структуре, о принципах, но и должно быть знание решения определенного казуса. Я был очень рад, я был в университете слышать, что вид тестирования – это решить казусы. Я поздравляю, по-моему, это правильно. По-моему, правильно. Хотя, возможно, там есть еще возможность, по-моему, улучшить. Почему? Потому что я так понял, что пока спрашивают только определенные, вы должны ответить на определенные вопросы. У нас такие вопросы не дадут. Вы, студенты, должны сама найти интерес сторон и на базе интереса найти подходящие нормы и потом применять такие нормы. И это общепринятая техника, которая и у нас, но в Англии, если вы ищете, если вы гуглите IRAC, Issue Rule Argument Conclusion, это похоже. Это похоже. И вот моя просьба, мое самое важное замечание сегодня, что вы в вашем обучении, пожалуйста, не совсем сосредоточьтесь на такие новые техники, но вы должны уметь такие виды аргументации. Дополнительный аргумент. Конечно, уже давно были попытки такая юридическая методика переводить компьютерный язык. Попробовали наш континентальный подход программировать. Все попытки не удались. Что сейчас произойдет на базе этих больших языковых моделей? Подход другой. Они собирают все возможные информации, и на базе этих информаций компьютерный программа или алгоритм выдаст новые решения. Но извините, для этого нужна база определенных решений. Такого пока нет. Это ваша задача. Вы должны разрабатывать. Вы должны разрабатывать такие судебные решения, потом, возможно, разработать. Это доводит меня к коротко размышлять, в чем цель юридического образования. Конечно, зарабатывать деньги, окей. Но по нашему думке это больше. Это больше. Подготовка профессии, но способность правильно решать неизвестные. неизвестные. Это должно быть, вы должны решить проблемы, когда никого не решили. Это ваша задача. Вы должны самостоятельно. Суд – это квалификация судья, он должен самостоятельно, независимым принимать решения. Пожалуйста, вы должны быть готовым самостоятельно и отвечать на это решение. В конце концов, вы будете кого-то послать в тюрьме, отказать в своем иске о туче денег, чтобы он попасть в банкротство. Вы принимаете. Или адвокатом вы поможете ему, или судьей. Для этого надо знать эти техники. Разрешите, арс бонит экви, вы, вероятно, знаете. Это, вероятно, это из римского права. Вот это цель юридического образования. Арс – это искусство. Искусство. Это больше, чем алгоритм разработки. И, конечно, как я уже сказал, это вы должны быть лучше, чем машина. Юридическое образование, да, может быть, это... Да, минутку я еще говорю. Как еще возможно улучшить образование? Разница между образованием у вас и у нас, это, я сказал бы, 2 пункты. Первый пункт – это какой вид тестирования. У нас есть после первого этапа обучения, это госэкзамен. Госэкзамен. Значит, не университет, не университет определяет экзамен, но это, я сказал, объективный. Второй пункт – это вторая этапа образования, практическое образование. У нас это тоже урегулировано по закону, чтобы государство определяло, что все юристы, которые имеют свой второй госэкзамен, имеют похожий уровень знания. Сколько я знаю в ваших странах, пока это, пусть каждая профессия отвечает за свое образование самостоятельно. Возможно, так сделать, но предложение было передумать. Может быть, это смысл и другой системы. Время закончится. Большое спасибо.
Спасибо, профессор, за ваш содержательный доклад. Now I turn to our next speaker, Professor Horace Young. He's a professor of commercial law and director of LLM program in international commercial law at the University of Leicester. He studied at 3 universities, the University of Hong Kong, Lancaster University, and the University of Oxford. Horace Young is a fellow of the Association of Chartered Classified Accountants, a member of Honor Society for Business Scholars, and a fellow of the Higher Education Academy, an arbitrator of the Guangzhou Arbitration Commission in China, and an external examiner for 3 UK universities. As an expert in legal education, he will give a speech on using AI in assessment, some observation and reflection from the United Kingdom. Professor Horace, the floor is yours.
So thank you so much, Professor Bashilo, for your introduction. Other than a member of Leicester University, I also regard myself as a member of TSUL, as a Central Asian Legal Research Fellow. So I'm very thankful for you as well as TSUL. So today I will talk about using AI in assessment, which is a widely discussed issue. So not just in Leicester, I'm quite sure the same across all law schools in the UK as well as all law schools in the world. So it's actually quite difficult to speak as the second to last speaker, so let alone the final speaker, as well as so it's quite difficult to speak in the last section in an exciting 2-day conference, because I believe all the good points should have already been covered. So if I sound too repetitive, so please bear with me, so I will try to be quick. So in case you have never heard of Leicester, then I think some of you may have heard of Leicester. I think the reason will be, so we have a top right-hand corner, so we have a world-famous football club who achieved miracle in 2015 and 2016. And then, so also from the slide, you can see our law school. The top left-hand corner is our law school building. And then the bottom left-hand corner, you can see our law library. And then on the right bottom corner, you can see our city center. So if you have the chance to come to Leicester. So to say a little bit about the policy that we have in governing the use of AI in student assessments. As I said before already, so my contents may be repetitive because I believe if your memory is good, so you may have seen something like this already in the first presentation by Professor Simon. So we have adopted a similar model to Sussex, so in Leicester. So we have adopted a traffic light system. So we have red color, amber color, or you can call it orange or yellow, and then finally green color. This traffic light system means that, so for red color, so it means that, so for this piece of assessment, then the students should not be permitted to use generative AI. So they should not use it at all. And then, so in the middle, we have the yellow or amber color. So it means that, so they can use AI in certain way. But the role of using AI would be sort of a research assistant. So it can assist you in the development of ideas when you're writing up the assessment, but in no way so it would help you to write up actually any parts of the contents of your assessment. And then finally, so we have the green sign. It means that so in this piece of assessment, it means that so students would actually be expected to use AI. In a conference in Malaysia, so in a consortium meeting of 16 universities in Malaysia, we talk about so how we can incorporate AI in our assessment. One way to come up with a green assessment would be, you can ask ChatGPT to generate maybe a short essay, and then so based on these short essays, then the students would be asked to critique on anything in this AI-generated short essay. So this is one common way for you or for us to how to come up with a piece of green assessment according to this traffic light system. So I'm quite sure, so you may not be that interested in how we do things in Leicester, but you may be more interested in a leading university in the UK. So I take Oxford, University of Oxford as an example. I did my PhD there. So basically for all the universities, I haven't really checked, but I believe so this is the case of basically virtually all universities. So nowadays, they would have a very clear AI policy put on their website. So you just Google AI policy and then university name, then you should be able to locate the policy of any university, at least in the UK. So if you go to the website here at Oxford, then they have some general arguments to talk about the plus side and negative sides of using AI. So for example here, so on the plus side, so University of Oxford recognized that so using AI is almost inevitable, and that it can improve the society, including education. And then also, if, according to Oxford, so if used appropriately, then it can actually help learning, but not hinder learning. And then at the same time, so there are negative sides of using AI. So one issue would be integrity. So when you write up an assessment, then you're supposed to be author. So when you ask somebody, or if you ask AI to complete an assessment for you, of course, so you can't say so it will conform to the idea of integrity. And then also, so another negative point put forward by Oxford in relation to use of AI would be, so when you go to university, you want to polish your intellectual skills. If you rely on ChatGPT, if you rely on generative AI, then you are not learning anything at all. So, and then so based on these side and positive sides, so they also come up with some broad principles. But one thing I have to say would be, so this list of broad principles that you can see in the slide here is not unique to University of Oxford. Actually, for all Russell Group universities, you can consider it as Ivy League equivalent in the UK. So in the Russell Group of universities, so we have 24 universities in the UK. According to this broad principle, which is actually based on the Russell Group principles on the use of generative AI tools in education, so you can see some broad principles like the university will support students and staff to become AI illiterate. So they recognize that it's actually essential nowadays to use AI. So, and then also as a member of academic staff, so recognizes that it's inevitable so to use AI. So then the role of university, the role of the staff would be to ensure that so we would equip the students with the right ways to use AI. And then at the same time, we also need to ensure the academic rigor as well as we have to ensure integrity. And then by coming up with this Russell Group policy, then you can see that so each university is not working on its own, but rather, so just like what we are doing today, so different universities will try to come together to figure out the right way to use AI. And then, so based on these broad Russell Group policies, and then so University of Oxford has also come up with some more specific policy. For example, the first point, so they say that the use of AI can be supportive tool in learning so long the use is ethical and appropriate. So to interpret it in my own words, then, of course, so we know that so it's inevitable. So we need to use AI in some way. So that's why we should not try to avoid it, but rather we should try to embrace it. And then the second point would be, so which is quite consistent with our university policy in Leicester. So the university will not really try to come up with a one-size-fits-all framework and then push it down to individual departments, to individual modules, to individual staff. Because so as an academic staff who teaches on the module, so we should know what should be the best way forward. So that's why to go back to the traffic light system, so it's up to them, the academic staff, who teaches on the module to decide whether we want to go for red, whether we want to go for yellow, or whether we want to go for green. And then another important thing would be, so when the students use AI, then they have to give proper acknowledgement. And then finally, so if you use AI and then something goes wrong, then according to this Oxford policy, then it is the responsibility. If you want to use it, then use it with care. And then if something goes wrong, it is your responsibility. You can't bring the staff. You can't really bring the university. So as I have said, so we can't really avoid the use of AI nowadays. So to support this by some statistics, so it is quite a recent set of statistics that is compiled by the Higher Education Policy Institute, a UK think tank. So according to, so it's not just specific to law school, but it's across the whole university, different disciplines, different departments. So as you can see that, so 92%, so almost all the students have admitted that they are using AI. So the way of why they use AI would be, so they try to be clear about certain concepts, to help summarize readings, as well as to suggest some research ideas. And then, so 18% even include some text generated by AI in their assessment. And then, as to the reason why they use AI, because so it can be more efficient, it can help them to complete the assessment quicker, as well as so they believe that so if they don't use it, then they may be put in a disadvantaged position. But at the same time, they have their own worries in using AI. But of course, I think the most important worries would be, so if they don't use it properly, then they will be accused of academic misconduct. So other than students, so this is law specific in relation to the law firms. This is a survey by LexisNexis. So according to, again, quite recent survey, last year, 2024, so according to LexisNexis, actually 4 out of 5 lawyers so, have admitted that so they are using AI or they will be planning to use AI. And then also we can see a quote here from one of the law firm. But however, so because I'm running out of time, I won't repeat the quote here. So of course, so when we use AI, so as I have said, so we should embrace it, but not avoid it. So as a result, so when we are using AI, so we have to exercise caution. One caution would be hallucinations. So something that I believe so have been covered by other presentations already. So the threat here is real. As you can see, this article extract from The Guardian, a newspaper in the UK, it's happened in Canada, it happened in US, it happened in Australia as well. It's also happened, of course, in the UK as well. So AI like to mix up facts. So for the lawyers, then, when you use AI, then AI will try to make up some fake cases. And then if you put forward these cases in front of the courts, in front of the judges, then you, as a lawyer, would be in trouble. Second thing would be, when we are using AI, then the consideration would be, should we regard AI as a tool or a collaborator? Because so if we regard AI as a collaborator, then of course, we have to give proper acknowledgement. However, if we regard AI as a tool, then we have to consider what should be the extent that we have to give acknowledgement. Because when you're writing up your essay, not just AI, you may use Google. So do we need to give acknowledgement to Google as well? And then you are writing on your computer, do we need to give acknowledgement to your MacBook as well? In relation to this question, so it's somewhat answered by a Supreme Court cases in the UK. So if you are an IP lawyer, if you are a law and tech scholar, or if you are interested in law and tech, then I believe so you may have heard of these cases. The idea of this case would be, so in theory, it's a non-issue. Because so if it is the patent that is the petitioner wants, so they can argue that, so I'm just using AI, the machine, as a tool. Then the patent can still be registered in the name of a human being inventor. But however, this is actually a test case. The petitioner filed that for a reason, to test that whether we will accept AI as an actual person. Apparently, according to this Supreme Court case, the answer would be no, at least under the Patents Act in the UK. So when we say an inventor, so it must be a natural human being like you and me. And then one more caution, the final caution would be, so what do we need an education for? I think there can be 2 views. One can be transactional, one can be transformational. For transactional, if we are just preparing the students to do their job properly, then of course so we have to encourage them to use AI. However, if the purpose of a university education is transformational, then apparently we have some other goals that we have to pursue. We have to ensure that the students have good integrity, and then we have to ensure that they are able to think independently. Over-reliance on AI can be an issue in this regard. So to sum up my my presentation, so I would want to use something like this. So it's a journey. To get from A to B, there are different ways to do it. You can walk. If you want to do some exercise, it can take longer, but of course you can walk. You can also drive. And then also, nowadays, we also have autonomous vehicles. So this is, I think, the part that is quite controversial at the moment. Of course, I don't know about the law in your spare time, but at least so in the UK, currently we don't accept autonomous self-driving vehicle. To put it in the context of this presentation, so students, when they are doing an assessment, they can write that up themselves. Then, of course, no issue. And then also, they can use AI as a tool, as a research assistant. Again, I don't think that is too controversial. But however, the most problematic point here now would be, so if they just rely on ChatGPT to generate an essay, for them, then it is definitely a no-no. But however, to be honest, so nowadays, it can come to a point that we have full automation, everything, virtually everything. I think just like this opinion from Elon Musk, so sooner or later, so everything will be automated, and then all us will be out of our jobs. So it just depends on when that point will happen. So that is everything that I wish to talk about. So thank you so much for bearing with me.
Thank you, Professor, for your speech. And now let me turn to our last speaker for this panel, Professor Søren Kroll. He's a renowned German tutor and lawyer. He founded Jura One, a tutoring company specializing in individual preparation of students for legal examinations. He also created an educational platform, Jura Online, which has been used by over 100,000 students and legal trainees. Professor Kroll has diverse and rich academic background. He received his German-Danish high school diploma from Duisburg School in Flensburg. Then he studied in California, United States, and continued his study in literature and law in the University of Copenhagen and Aarhus. Later, he was awarded a scholarship from Queen Mother of Denmark and obtained law degree from University of Hamburg. In addition, he's a founder of the Hamburg-based law firm Jura Contra, which specialized in examination appeals and capital market law. He will give a speech on how to create an intelligent legal online teaching platform. Professor Kroll, the floor is yours.
Thank you very much. Since I am the last speaker, I first of all want to take the opportunity to say thank you for a well-organized and inspiring conference. And I'm not making it too long, but I have something to say. At the end, maybe I will have the vision of a teaching avatar. Just briefly to my person, you already introduced me, but I can say about myself, I'm a German lawyer and a German law tutor. I'm founder and CEO of Jura One, and Jura One is specialized in individual, that means one-to-one teaching to law students to prepare German law students for the exam. And to understand the origin of Jura One, you have to know the situation at the German, in the German law education. It's very, very competitive, and about 90% of all law students take private courses in addition to the university to prepare for the exam. However, it's quite expensive to take these lessons, especially when it's one-to-one. And so not everyone can afford it. And on the other hand, we noticed that the number of good tutors and the time of good tutors is limited. So that's why we came up with the idea to found Jura Online, which is an intelligent online digital teaching or learning platform. Was about 10 years ago. And the idea was to transfer as much as possible of the offline experience to an online teaching platform. Not only the contents, but also the didactic concept and the guidance that we give to our students that get a one-to-one coaching. And so we started producing about 1,500 videos in small entities, so you're able to learn it. And also we did some scripts related to these videos, and we added some technical features to enhance the learning environment and the experience that the user has when he uses the platform Jura Online. So the vision was to create something like an online teaching coach that takes you from scratch guides you all through your studies and gives you all the way to the exam. That was the beginning about 10, 12 years ago. And so when you create an intelligent online teaching platform, you have to take into consideration different aspects. The first thing is you have to analyze the framework conditions and the user cases. So one thing is you have to analyze the law system. Some countries have a case law system which is deductive, which means you have the case and you deduct the rules from the case. Other systems are just as Germany, law-based legal systems, inductive systems, where you first get the rule, and from the rule you have to apply the rule to any case, whatever case it is. Another thing you have to consider if you create an online teaching tool is, should it be a learning platform, a full-scale learning platform with all the contents that are needed for the exam, or should it also or only be a reference work where you find single information to seek for a certain answer to a question that you have? And as far as user cases are concerned, you have to consider, does the user want to use the online platform at home, at the desktop, or maybe on the go as an app? That's important for some technical decisions such as the API. The next consideration is you have to analyze the learning personality or the different learning personalities. Some users are inductive learners. They prefer to get the abstract theoretical learning units and want to learn them, and afterwards they want to solve cases. Some others prefer, even in an inductive system, to start with the cases and come from the case to the rule and learn the rules. Some users are visual learners. They need the videos, so we produce the videos. Some others are acoustic learners, or they only want to use it acoustic when they run around the lake. They only want the audio. Some are even haptic learners. Although it's an online platform, we have all the scripts you can print out and do the marks on the printout. And also you have to consider different personalities. You have playful learners. That means people that want interaction with the platform to get a reaction if you achieve a goal. Some others don't want to be disturbed by the platform and want no response from the platform. You also have to consider that in the communication with the user. And last but not least, you have to enable the user to customize his learning experience. So for instance, in Germany, we have the states, the federal states, and they have different, especially public law. So you have to make it possible to choose your own public law for your federal state. Or some students only want to learn civil law. They don't want to learn criminal law, so I have to be able to remove certain contents and learning units. So what are the key requirements if you create an intelligent online teaching platform? I would say there are three things that are important. First of all, bindingness. Number two, operability. And number three, transparency. Bindingness means that you define the contents and make the user learn the content so he won't forget the contents. Operability means that the user should be able to use the contents on a case to solve a case and even the unknown case, a new case. And if you leave someone alone at home learning online, there are always two questions. Am I fast enough? Am I in time to learn for the certain point that I have chosen? And do I learn well enough? So the program has to show you if you are in time and if you are learning well enough, if you will achieve your goals. So that's two very important questions when you leave people alone learning online, so they can control themselves and be confident that they're on the right way without a real coach. So let's take the bindingness, or other word, compulsory learning. I also call it knowledge. As a content producer, you have to define the learning contents. I call it canonization. So you have to define this is the content that he has to learn, or at least should be have accessibility to learn, and you have to separate from accidental contents that is nice to have. So you have to define what is necessary, need to have, and what is not necessary, nice to have. And only the need to have, the eternal learning content, has to undergo a procedure for bindingness. That means after each video or text or end text, we have some test questions related to the learning unit, and so the user has to type his answer to this question, and we have deposited the correct answer, and as he has given his solution, he will be shown the correct answer, and then he has to decide himself if it's correct or not, and we're helping by highlighting the matches in his answer. But this is a problem because, of course, there's a possibility to cheat. I don't want to say that German law students cheat, but at least there's a chance to cheat at this point. But we have so many user data, I think many millions, maybe 100 million user data for the answers they have given. So we can, we will be able in the future, I'm sure, to use AI for the syntax and the wordings to give the estimation if it's correct or wrong by the platform and not the user giving it himself. And to make it binding, you need review units. That means regularly you have to repeat what you have learned, the learning units, and cumulative, so you won't have the feeling at the end that you have to start from the beginning because you have forgotten most of the things that you have learned in the beginning. So we got especially these review units. They are important for the intelligence that's in the platform that I'm talking about in 2 seconds. But a second issue, as I said, requirement for online teaching platform is operability. You have to be able to use what you have learned, abstract, theoretical, in the learning units on cases, to apply the rules on new cases. And what we have done, we have put links underneath the learning units to link to all the cases where you find this theoretical knowledge applied in a case study. And the other way around, at the cases we have put links underneath where you can get to the relevant theoretical units where you find out what should I have known to be able to solve this case. And one thing that we noticed very important is coherence. That means that you have the same wording, the same structure in your theoretical learning units and in the cases, so you can recognize and find the theoretical parts that you have learned in the case and see it in an active context. Here is the biggest problem, at least in Germany, we don't have multiple choice. In many countries also, you have to write case studies, maybe 10, 15 pages in the exam, to have a feedback, an individual feedback on this, on your solution. And that's the part where I see the biggest problem to make it completely intelligent and to have it correct. But we have many data to be able to at least try to have the program control this individual solution to this study case. Okay. Now, transparency. So we have created 2 things. We have created a learning navigation system that is giving answer to, am I learning fast enough? So the user selects the content. The program makes a basic assumption regarding the learning speed and records a different individual difference in the speed and tells you and displays the date you will reach the goals with the contents that you have chosen if you continue in this speed. So you can decide if you want to learn longer and postpone your exam, or if you want to learn more or not as intense to reach the time goal. Last thing, transparency. Recording, am I learning well enough? Is the quality good? We are recording the review questions, and out of this review question, you get the confidence factor. That means the probability of being able to recall this information in the exam. And we have programmed to simulate forgetting. So if you do the review, the cumulative review units, quite often you will get ideally to 100%. If you don't do them, it goes down, and in one moment you can see for all the things where you stand at the different topics you have chosen. So what do we have to solve? Automatic checking of test answers, individual feedback on case studies, the coach that analyzes and tells you you are in time and maybe you should learn more or do more review. And what we won't solve is the social interaction with the clients and that you need later. That is something you can't learn on a platform. And my last question and perspective is, will it be blended learning as now? I guess we have maybe 50 or 60%, or will we close the gap and reach 100% with all the technical solutions that we have implementing AI to make better law students? Thank you very much.
Thank you, Professor, for your speech. And due to our time limitation, I would like to skip our Q&A session, and I'm going to wrap up our session. And first of all, I would like to thank all our distinguished panelists for their insightful presentation and engaging discussion throughout this session. And I also would like to express my gratitude for all participants for their thoughtful question and contribution. Also, I want to thank the Minister of Justice of Uzbekistan for their terrific work in organizing of this event. And special thanks to our interpreters for their accurate translation. And thank you again for attention and active participation in this session. Now, finalizing this forum, I would like to welcome all of you, speakers, and anybody who wish to join us for photo session. Thank you. We'll organize photo session here, please. Who want, please come here to make a photo session.